None appears, dismissed or not possible.
Special weekly list, item 2.
None appears, dismissed or not possible.
Special weekly list, item 3.
None appears, dismissed.
Item 2 I am appearing. Item 2.
Yes, tell us.
Kindly come to order number 4, dated 18/8/2017. This matter has been referred to the full bench.
All right. When is the matter coming up in the full bench?
28th June.
Okay, list on 28th June, the date already fixed before the full bench.
28.
28, is it?
28. 28th June.
Special weekly list, item 3.
None appears, dismissed or not possible.
Special weekly list, item 4.
I am for the appellant, my lord. I am for the appellant, my lord. I am challenging the award, my lord. 3 lakh is awarded, my lord. Challenging the provisions of 163 came into force on 14/11/94. And then same is retrospective, applying the scheme is not applicable, my lord. We, not a single judge, are not allowing our 170% of the MV Act, my lord, to contest all the governments the insurer, my lord. And another point is a contributory negligence, my lord. Accident occurred on 19/11/92, my lord. And challenging the award, my lord, only on the contributory negligence, my lord. The deceased is a cyclist who was dashed by a tractor and trolley, my lord, on the backside. And Howard, he is earning.
Anything else, sir?
My lord?
Anything else?
No, my lord. And only challenging the provisions of 163A came into effect with effect from.
Actually, after very brilliant senior advocates in the Supreme Court, I'm now watching a lawyer who can argue without a brief.
The brief is not found, my lord.
No,
Sorry, my
are-
lord.
Actually,
Sorry,
one
my
has to salute you, sir. Salute you.
I have
That
seen
you are
the
able
file
to
here.
argue without a brief.
No, my lord. I have
No,
seen-
that is remarkable, sir.
No, I have seen the file
It's quite
here.
remarkable. It's quite
The-
remarkable.
I
It's
have
all right. It's all right. Anything else, sir?
Yes, that's all.
All right. Dismissed. We'll pass the detailed order. All right.
Special weekly list, item 5.
My lords, no instruction.
Counsel for the petitioner states there are no instructions. All these dismissed.
Now gradually all the racks are being cleaned up.
Good.
And I can tell your lordship,
Yes,
before lordship assumed the office of the chief justice,
yes.
there was no reporting so far as direct tax was concerned for last 6 years, at least from 16.
Right.
Now every time judgment is being reported.
Also indirect taxes.
Yes.
All right.
Special weekly list, item 6.
Item 6, Lordship.
Yes.
By effluence time, it may become infructuous. My Lordship, kindly see one order is passed, that is order.
No, it's
dated-
okay. It's okay. It's a
Lordship,
counsel for the
they-
petition. You're for the petitioner or for the respondent?
I am for the petition, Lordship.
Ah.
Here, Lordship, on order number 3, 27th April 2021,
Ah.
one order is there. I am reading out, Lordship. In the meantime, as an interim measure, it is cited that the petitioner shall be permitted to catch fish in presence of an officer deputed by Block Development Officer Nalla, and the value of the fish shall be deposited before the BDO, Block Development Officer. To stop, necessary direction regarding disbursement of such amount can be made at the
Oh.
time of disposal of the writ
So
application.
that amount has to be disbursed.
That Lordship may observe that.
Counsel for the petitioner states that the petition has worked itself out and is now infructuous. in terms of the order dated 27th April 2001 passed by this court. A direction is issued to the block development officer to disburse the amount payable to the petitioner at the earliest and in any event not later than 4 weeks from today.
Lordship, grateful.
The petition
The
is
order is 27/4/22, 27 April 2001.
Correct.
Lordship, grateful. Lordship.
Right.
Okay.
Special weekly list item 7.
No, no.
I am appearing for the petitioner in this case, my lord.
Yes, yes. Tell me.
My lord, kindly take me up, after lunch.
Why? What's the reason, Mr. Mishra?
Just now just now found out the brief. I'll just go through that and I'll submit.
All right. At 2 o'clock. All right.
Obliged me.
Special weekly list item 8.
Special. Delhi. No instruction.
All right. Counsel petitioner states he has no instruction.
Special weekly list item 9.
My lords, no instruction.
No instruction.
Special weekly list item 10.
Lord, this case is covered by your lordship's judgment, my lord.
Ah.
What has happened here, my lord? Petitioner before my lords is a small scale industrial unit under IPR 1996. Petitioner is entitled to sales tax exemption for a period of 7 years from the date of starting its commercial production with effect from 5/9/1993. So for the eligibility certificate is concerned, my lord, the general manager DIC Rayagada has issued the eligibility certificate to the petitioner that has been ignored by the sales tax authorities. To that extent, following the judgment of the Honorable Appeals Court Badikal Chemical case, your lordship has delivered the judgment in my case. Kindly. Paragraph 15 and 16.
Right.
Your lordship is judgment.
Yeah.
Lord, am I permitted to read, my lord?
No, sir. All right. This is Orissa Medical, right? Which is this item?
10.
4318. Konark Alum.
My lord.
The prayer in the present petition is for a direction to the the challenge in the present petition is to the assessment order dated 28 July 2002 passed by the sales tax officer Koraput 2 Circle. Declining the prayer of petitioner for sales tax exemption as per the eligibility certificate issued by the District Industry Center, Rayagada, bracket Annexure 4 series. It is not in dispute that the prayers in the present petition are completely covered in favor of the petitioner by the judgment dated 5th May 2021 of this court in WP Civil number 188 of 2006, Messrs. Krishna Steel Industry versus the sales tax officer. That is the matter. The impugned assessment order is hereby quashed. And a direction is issued to the department to but nothing, they've not collected any tax from it. Okay, no,
Stay is
that.
there, my lord. When I filed the case, you lordship passed the interim order that is continuing till date.
Yes. And then if this is quashed, the petition is disposed of.
Obliged, my lord.
All right.
Special weekly list item 11.
May I please, Lordship? The questions of law is at page 10 of the brief, my lord.
Not yet framed, sir.
The petitioner claimed it to be a ready-to-use garment and paid tax at the rate of 4% under entry 84 of the tax list, my lord.
So what happened to the department's revisions 6, 7, and 8?
Department revision was on another aspect which has been they have considered, and your lordship has allowed rejected the revisions.
I see. So department's revisions have been rejected. Where is that order? You have that order.
Order, I don't have that.
All right.
That was pertaining to, my lord, issue number. There were actually 4 to 5 issues before the tribunal, my lord. One of the issue was it relates to IPR, my lord. That is, whether it will amount to first point sale or not, that has been decided by tribunal has ruled in favor of the assessed, my lord, and the revision was rejected by the
All right.
honorable court.
All right.
But so far as question of first question is concerned, my lord, the
This is
appellant
a classification question.
classification question.
Ah,
It is burden, your lordship knows, my lord, while interpreting the entries, my lord, the burden is on the revenue to establish whether it will fall under the regular entry or residual entry, my lord. So now that point has also been decided by the Honorable Supreme Court in Voltas Limited versus State of Gujarat, that is reported in 80 VST, page 12, Supreme Court. At para 21, Honorable Supreme Court has held, my lord,
the burden of proof is on the department.
my lord,
Burden of proof is on the department.
my lord, my lord.
Ah. No,
In this
which is the concessional rate for you?
It will be 4%, my lord. I have paid 4%,
No, if it is in the main entry.
4%.
No, you're bringing it to under which entry?
Ready-made garment.
Ready-made garments. Diapers are ready-made garments.
My lord, but it's a garment, ready to use garment, my lord. Ready to use garment. And
Do you have any other case law on diapers specifically?
diaper, my lord, unfortunately, I could not get any.
What is the reasoning of the tribunal? Let's read that.
My lord, the reasoning of the tribunal, your lordship may kindly turn to page 104 of the impugned order. My lord, 103. The findings with regard to all these issues now before your lordship is they have dealt it in paragraph 26B,
Correct.
page 103. But this is the one paragraph finding, no reasoning, nothing.
In fact, your lordship would file the detailed reasoning at page 66. That's the first appeal order. Page 66, first paragraph. There the detailed reasoning in this respect.
The tribunal has simply confirmed the finding of the.
So let's read that reasoning then.
My lord, my lord.
Page 66.
May I read it, Doctor?
Yes.
The LA appearing in this forum did not contest the taxing of the sale turnover of Kotex sanitary napkins at the rate 12% by accepting the conclusion of the LAO in treating the sale of Kotex as sanitary napkins. But he vehemently contested the taxing of the sale turnover of Huggies at the rate 12%, treating the same also as sanitary napkin. It was submitted with physical production of the sample of Huggies that those are hosiery goods or ready-made garments exigible to tax at the rate 4%, but not at the rate 12% as erroneously adopted by the LAO. After verification of the sample of Huggies produced, this forum sees that even if the nomenclature of both the goods differ, their commercial or consumer utility remains the same. The solding or absorption of watery substance oozing out of the body. Huggies can never be treated to be hosiery so far as the commercial utility of the item is concerned. In view of this, Kotex sanitary napkin and Huggies belong to the same class of goods, exigible to 12%. In view of this, the contention, but my lord, your lordship will see that I don't say that it is the hosiery goods. I say It's a ready-to-use garment which has not been dealt
No,
with.
no, it's not a garment, sir. See, something that you wear in, you don't wear it out, right? Even for babies, you don't, except when babies are at home. These are Huggies are for the babies, is it?
Babies.
Yes.
I'm
At
saying
that point of time,
the
it was,
purpose,
those were
the
meant for
function of
babies.
the function of the diapers is very akin to napkins. They
But,
absorb.
normally, my lord, the kids also, we take out the kids with the Huggies and their.
No. Even then, you put a regular dress on the kid, on the baby.
So it will at best we can say it to
It's
be
an undergarment. Sir. It's never a garment.
It can
It's
be
an
said to be an
undergarment.
undergarment. And
So that's different from a ready-made garment. The ready-made garment is something that you actually wear as a dress.
my humble submission before Lordship would be that since the entry is very wide in term, bringing in hosiery and ready-made garments, and this being an undergarment, so I humbly say that my lord, it will come under 84 entry 84 of the tax list.
Right. Aegisdum generis, right? Some hosiery items can be actually worn as ready-made garments. Some hosiery items, but undergarments may not fall within that. Let's see the entry. You have the entry. Which page is that? That's it. What's the entry number?
Entry 84. Lords. If your Lordship is holding this book, my lord.
Correct.
So it is at OST rate, page 60. List C.
Right. Hosiery goods and ready-made. This is not hosiery, sir.
No, this is not hosiery. This is not hosiery, but my submission would be that it may be treated as undergarment, which will be in the wide connotation, my lord, of ready-made garment.
Not really. We're not convinced of it. So question 1, we decided in favor of the department. What's question 2?
My lord, question number 2 is it relates to trade discount, my lord. Whether the tribunal was justified in upholding the finding of the learned assistant commissioner regarding claim of reduction of the trade discount, while at the same time holding that law permits such a reduction on account of trade discount, and whether such finding is contradictory. Your Lordship may kindly turn to the finding of the tribunal, where the tribunal holds that it is legally permissible, but at the same time affirms the findings of the learned assistant commissioner. No discussion, nothing, my lord. And this point is now, my lord, it is no more deciding. It has been decided by the Honorable Supreme Court in a number of cases, my lord. Starting from, my lord, Advani Orlicon's judgment, Bombay Tire's judgment, and IFB.
So in arriving at the taxable turnover, you allow a deduction for trade discount, my lord. What's the citation? Advani
Citation is 45 STC, page 32, Supreme Court. Deputy Commissioner of Sales Tax Law, Board of Revenue Taxes, Ernakulam versus Advani Orlicon Private Limited.
Giving some other judgment. What you've given us is IFB Industries.
And the next judgment is
All right. All right. What do you have to say on this?
Yeah, in fact, my lord, on this point, the tribunal has held it in favor of the assessee because my lord,
No, that's precisely what he's trying to say.
yes, my lord.
Ah,
But at the end, he has said that the order of the first appellate authority is
by
justified.
mistake. All right. Then third question.
the third question is regarding enhancement, my lord. Within the facts and circumstances of the case, while the revenue had failed to discharge its burden by showing the details of the consignment alleged to be purchase suppression by making a cryptic reference to the same in the alleged fraud report and enhancing the turnover by rupees so and so by 10 times, my lord. My lord, what has happened in this case, my lord? Factually, the petitioner doesn't have any manufacturing unit. So, by way of branch transfer from Andhra Pradesh, goods had moved to the state of Orissa under the government waybill of Andhra Pradesh. Now, 45 consignments were brought in. At the time of intelligence inquiry, my lord, it was found that 44 I could able to explain about 44 consignments. Now, one consignment that is for rupees 10 lakhs amount. That I could not trace the documents. So that treated it as suppression and enhanced the turnover by 10 times.
So did you trace the documents at all or not?
Well, 45 consignments were there. Only
No,
one
but
consignment
still-
I could not trace.
Huh.
And that is the finding also that I could not trace it.
No, but so what happened therefore? What happened to that consignment? How did it land up in the truck?
And
What's
it
the
was-
explanation?
it
Must be the
was-
explanation how you loaded it onto the trucks. There must be some document to show the loading at least on the
My
truck.
lord, the assessing the assistant commissioner takes note of the waybill number. In its order, the assistant commissioner takes note of the waybill number through which this consignment has reached Odisha.
No. There must be a consignee.
My lord.
Did you examine the consignee? You could have
The
easily
consignee
examined the
was-
consignee and said,
was the C&F agent of the. That has not been done.
so you had an opportunity to show that it's a genuine transaction.
In fact, enough opportunity was given, but he couldn't
I could not trace it, my
substantiate
lord. That's
that,
the fact I
that
cannot
transaction.
improve upon.
Couldn't give any document. so
No,
far
it
as
was
that-
meant. You see, when you're dispatching goods, even by way of branch transfer, it is for some consignee,
Yes.
some ultimate purchaser. You could have brought
Well, it
them
was-
before
it was consigned to my C&F agent only.
you could have produced him.
It was there, but I could not trace it. That is the finding, my lord. And
All
your
right.
lordship
Then
will
it's
see,
factual, so we won't interfere with that.
my lord, your lordship will see from the assessment.
This turnover by 10 times, is there any rule for that?
That is pinching, my lord, 10 times. My
So
lord,
what is the rule for that?
my lord, in that regard, my lord, I am relying on the judgment of this honorable court, where this honorable court has said that to the extent of suppression found, it has to be. So it
What
has
does
to
that even
be,
mean?
It has to be one time, my lord. This case reported in 26 STC 536.
No. So what? How many times was it there?
Well, it was around 6 to 8 times. It was enhanced 6 times.
No. But here, this whole thing has been set aside.
Well,
That can't be.
the finding the court.
What does the rule say? What is the rule? There must be some rule for this.
Well, best judgment
assessment.
assessment, my lord.
Based judgment assessment, my lord. There is no governing rule, my lord. And my lord would consider here the
2 times do we have it now? We'll reduce it to 5 times. All right.
my lord
Then,
would only consider the dealer is a mighty one, the Hindustan labor, and he is
and
not able
still,
to.
doesn't
that
mean
is-
that because the dealer is mighty, you'll start
But my lord,
multiplying it anytime.
he couldn't.
That's the whole problem about arbitrariness. You show me the dealer, I'll show you the penalty. Can't be that way. Yes.
My lord. The last question is whether the tribunal was right in allowing the tax adjustment not allowing the tax exemption paid at check gate in respect of tricycle, freezer, pushcarts, and stabilizers, my lord. My lord, in this case, the petitioner, while bringing in the goods, had paid some tax at the check gates. Now, at the time of assessment, he urged the assessing officer to adjust it against the tax paid. But that was rejected on the ground that these goods were not found in the registration certificate. My humble submission before your lordship is that these goods are ancillary to the sale, my lord, because the freeze is required for the ice cream dealer. Well, the dealer is deals in ice cream. A freeze is necessary. So therefore, the
No,
freeze
what are
was-
you dealing with?
my lord?
What are you dealing in?
I am dealing in manufacturing of ice cream and all. And so far as the promotional goods are concerned, my lord, the assessing officer, I mean the assistant commissioner has allowed it. The plastic goods were allowed, but tricycle as a promotional item was not
So
allowed.
Hindustan Lever manufactures what ice cream?
My lord, it has taken over Vadilal and
Oh, Vagila.
quality.
Oh, quality is it?
Yes,
Okay.
quality walls.
Which year was this? 2000 and
This is 98-99.
99, 2000,
98-99.
98, 99. What do you say to the last one?
But my lord, if that item is so relatable, then he could have followed the procedure of law. He could have applied for its incorporation in the RC, my lord. He has not done that. Now he has brought these materials. Those materials are not in the RC. So any tax paid at the check gate in respect of those materials, those are not allowed.
What does the rule say?
Lord, a rule says that it has to be incorporated in the RC so as to.
Show us the rule. No?
My lord.
The rule must have been discussed in the impugned order.
It has not been discussed. Simply say that it has not been incorporated in the RC, therefore disallowed.
What are the items incorporated in the registration certificate? What are the items?
Lord, the petitioner actually deals in.
How these items can be
I'm sorry,
treated
my
as
lord, the
ancillary?
RC copy is not there with me, but I deal in sale of branded soaps, detergents, cosmetics, tooth powder, tea, coffee, vanaspati, edible oil, tin food products, ice cream, etc.
So that ice cream, etc. That's the whole problem.
But ice cream is there, my lord.
Ice cream is there. We're not talking of ice cream, right? We are talking of.
My lord, I have not given the details, but I'm sorry, my lord, copy of the RC is not with me right now.
But that's still. See, the burden here was on you to show that it's in the RC.
It was not there in the RC. It is correct. It is not there, but I say it is relatable
got
to
it
the sale, my lord.
incorporated, sir. Would have easily got it.
Technicality should not, my lord.
No, tax, please. This tax laws, it cuts both ways. See, there are 4 questions of law that have been framed by this court while admitting this revision petition by the SSC on 30th July 2005.
2006, man.
2006. Right. Colon. Then reproduce from that order. Very good. The first question is an issue concerning classification. Stop. The case of the SSC is that the product in question, that is single quotes Huggies, unquote, which are actually diapers, falls under entry 84 of list capital C. So the schedule to the Orissa's Entry Tax Act, is it?
Sales Tax Act.
Sales Tax Act, which reads, open quotation, hosiery, goods and ready-made garments, unquote, and is exigible to 4% tax. Sales tax. Full stop. Paragraph. In rejecting such contention, the Assistant Commissioner of Sales Tax, bracket ACST, Cuttack, has noted that another product of the SSC, comma, open quotation, Kotex, Kotex, which is a sanitary napkin, has been treated as such and classified as falling under the residual entry, making it exigible to 12% tax. Stop. The ACST has concluded that given the nature of the function performed by the diapers, that is Huggies, they would be no different from sanitary napkins in as much as they are meant to absorb body fluids. Paragraph. Learned Counsel, the Orissa Sales Tax Tribunal, bracket tribunal, has in the order dated what's the date of the order?
Well, order dated is 10/7/2002.
10/7/2002.
7/10/2002. 7/10/2002.
7/10/2002, concurred with the above view of the ACST. Paragraph. Learned Counsel, the petitioner urges that single quotes Huggies, unquote, which are diapers, should be treated as single quotes ready-made garments, although they may not be single quotes hosiery. Stop. This court is unable to agree. Stop. Such diapers are usually worn as undergarments and cannot be properly understood even in commercial parlance, as single quotes ready-made garments. So in other words, they are not worn as a dress, but usually under a dress, even if it is worn by infants and babies. Consequently, the court is unable to agree with the contention of the SSC that single quotes Huggies should be classified as single quotes hosiery, goods and ready-made garments, unquote. The question is therefore answered in favor of the department and against the SSC by holding that the tribunal was justified in upholding the order of the ACST in this regard. Paragraph. Question number 2 concerns the claim for deduction of trade discount. Reliance is placed by the Learned Counsel of the SSC on the decision IFB Industries Limited versus State of Kerala, AR 2012 AC 1468, which has decided this issue in favor of the SSC. No, which has decided the issue that supports the contention of the SSC. Paragraph. In fact, the tribunal has in the impugned order accepted the plea of the SSC, but in the operative portion of the order on this issue has upheld the order of the the sales tax officer, bracket STO, declining deduction of the trade discount. Clearly, this is an internally illogical conclusion of the tribunal. Consequently, question number 2 is answered in favor of the SSC and against the department by holding that the tribunal was not justified in upholding the finding of the assistant commissioner, that is, the assessing officer, and in declining, who declined the claim for deduction of trade discount. Paragraph. Issue as regards issue number 3, Learned Counsel for the SSC submits that of the 45 parcels, is it?
Consignments.
45 containers.
Consignments.
Consignments.
Which were sent by branch transfer. Explanation could not be offered by the SSC by producing documents in respect of one such container. It is seen that despite opportunities, the SSC could not produce evidence to explain the branch transfer in respect of that container. Full stop. It is seen that the assessing officer has enhanced the turnover by 10 times by treating this as a single quotes fraud, unquote. The court is the view that enhancement by 10 times may be disproportionate and therefore modifies the impugned assessment order, as affirmed by the ACST and the tribunal, from 10 times to 5 times the turnover. The question is answered accordingly. Paragraph. The last issue concerns.
In fact, the provision malady, section 9, subsection 3.
Under section 9, bracket 3 of the Orissa Sales Tax Act, 1947, bracket OCT Act.
May please, on receipt of an application, the prescribed authority shall, if he is satisfied that the applicant is bona fide dealer and the requirements of the provisions of this act and the rules made thereunder have been complied with, he shall register the applicant and grant him a certificate of registration in the prescribed form,
Right.
which shall specify the class or classes of goods in which the dealer carries on business at the time of grant of certificate. So in that, these items were not there.
This issue is not in controversy, my lord. Fact remains that these goods were not
In the RC.
incorporated in the RC. Your lordship, at this juncture, if your lordship permits me, may I take your lordship to through rule 36 of the act of the rules, my lord. It says about payment of tax to be made before furnishing returns. I would rely on the last proviso, page 107. Last proviso, my lord.
Yeah.
Provided also that if any tax is paid to any officer in charge of check post or barrier, receipt for such payment of tax issued by the officer so and so or barrier shall be adjusted against the admitted tax payable by the dealer.
If it is the same goods which you are dealing with.
That must be relatable to the goods.
That is what my submission is, that these goods are relatable to the business with the.
No, unless it's shown in the RC, how will you know?
He could have, my lord, amended the RC also.
Say, counsel for the SSC, while counsel of the department refers to section 9, bracket 3 of the Orissa Sales Tax Act 1947, bracket OST Act, which mandates the incorporation of the goods being dealt with by the dealer in the registration certificate, bracket RC. Counsel for the SSC refers to the third proviso, Rule 36 of the Orissa Sales Tax Rules 1947, bracket OST rules, which permits adjustment of the tax paid at the check post or barrier against the admitted tax payable by a dealer. So it is submitted that in this case, tax on the tricycle, freezer, and pushcart paid by the SSC at the check post was wrongly refused to be adjusted by the assessing officer. And both the ACST and the tribunal have again erroneously affirmed such order. Paragraph. The court is unable to agree with the above submission of the SSC. Full stop. Although the RC of the SSC admittedly incorporates single quotes ice cream, unquote, which the SSC deals in, it does not contain the above 3 items. 4 items, namely the tricycle, freezer, pushcart, and stabilizer. Full stop. While these may be incidental to the selling of ice cream, unless these items are specifically incorporated in the RC, the third proviso to Rule 36 will not stand attractive. Full stop. Consequently, the court is unable to agree with the submission of the SSC and upholds the finding of the assessing officer as affirmed by the tribunal. The question is accordingly answered against the SSC in favor of the department. The revision is disposed of.
Much obliged. Special weekly list item 12.
May I please, Your Lordship?
Yes.
I am through VC, my lord.
Yes.
This repetition has been filed by the Lord Tribunal, that is under Annexure 1 at page, Your Lordship, page 13.
Sir, July 99 order was challenged in 2002.
My lord, that is right. But so Your Lordship is subject to correction if Your Lordship will take the order dated 29 2004.
I know. It was heard and stay was granted.
Yes, my lord.
Has the other side been served?
The other side, my lord, notice have been served and except 7, 8, 10, 18, 19, 20.
Sir, are they all still serving or all retired? Must have retired by now, sir. I'm sure.
Yes, my lord, must have been retired by.
That's what's the point, sir? Then we'll just leave the questions of law open.
My lord.
You say considering that the issue is about notional fixation of pay in the junior SES scale, taking into account the date of occurrence of vacancies of the opposite party school teachers, and considering the fact that they've all now superannuated, the court does not consider it appropriate to continue to entertain the present petition. Accordingly, while vacating the interim order dated 20th September 2004 and leaving the question of law that arises from the impugned order open for decision in some other appropriate case, and clarifying that the impugned order will not constitute a precedent, the petition is disposed of.
Special weekly list item 13.
Item 13, Miller, the sole petitioner died on August, Miller, in the month of August. So he's to be substituted. I am filing a memo to that effect. Yesterday,
What's the matter about? Tell us the main matter.
The annexure for the demand notice has been issued without any show cause, with threatening of demolish my building stands over my private plot. Annexure 4, page 30. The award was made. I reconstructed my building. Thereafter,
anyway, your stay has continued for how many years now? 19 years.
My lord, yes.
So you appear will continue the stay till the show cause notice is disposed of. You said the challenge, the present. You say the application for substitution is allowed. The challenge, the present petition, is to a notice dated 1st May 2003, issued to the petitioners by the additional Tahsildar and LAO cum CA, Berhampur, asking the petitioner to refund rupees 826,651 on account of damages under section 3 capital G 7 small b, the National Highways Act 96 (NH Act) on or before 6th May 2003. Paragraph, while directing notice to issue in the present petition on 6th May 2003, this court stayed the operation of the impugned notice. So that stay has continued. What about the cost you've deposited?
Yes, must have been deposited, my lord.
All right.
That is.
The stay was conditional on opposite parties number 1, 2, and 3 assessing conditional upon the petitioner depositing the assessed costs by 7th May 2003. Also, for the petitioner states that interim order ought to have been complied with paragraph. Considering that the interim stay has continued for over 19 years, for nearly 19 years, the court considers it appropriate to direct that the hearing on the above show cause notice will resume before the authority concerned, before whom the matter will be listed on 25th April 2022. The petitioners will appear before the authority on that date and submit their written response to the show cause notice without seeking any further time. After hearing the petitioners, the authority concerned will pass a reasoned order not later than 3 months thereafter, and in any event, not later than 25th July 2022. The said order will be communicated to the petitioners not later than 1st August 2022. Till such time, the interim order passed by this court on 6th May 2003 will continue. The court clarifies it has not expressed any view in the matter. The petition is disposed of.
Petitioner died on 16/8.
My lord, in place of petitioner, the legal heirs of the petitioner.
Legal heirs, obviously it means that once the substitutions are allowed.
Special weekly list item 14.
Am I audible, my lord?
Yes, please.
My lord. My lord, this matter, in fact, disposed by the Honorable Apex Court, and Lordship have a kind glance to Order 15, dated 11/3/2019. Order 15. 11/3/2019. After the disposal by the Honorable Apex Court, the matter has been taken by the Honorable Court on 11/3/2019. May I place that?
Yes, yes.
My lord. My lord, this is an order and consent of both parties. That's why I'm just reading the para that's quoted by my lord. The submission of the London Senior Counsel for the parties is fair and reasonable. By the impugn order of the High Court had directed the board and its committee on chrome ore sell price to work out and determine the sell price of 4042 grade chrome ore supplied to the respondent, either by consultative process or through price setting tender, keeping in view the determination made in respect of others in that meeting dated 25/10/2005 and 12/12/2005, and the sell price determined for the sell chrome ore in the domestic market of the corporation, and also have regard to the prevailing price as adopted by the appellant and the state government in the case of Vedanta Alumina Limited and others. Then the next sentence is very important. In our opinion, the exercise as directed by the High Court is not necessary in view of the agreement between the parties as noted above. For the ready reference, the chart is made part of this order and annexer A. Then my lord, annexer has been put. Accordingly, it is directed that for the supply of chrome ore, 41% by the appellant to the respondent for the period 1/7/2003 to 31st December 2003, the chrome ore price shall be 1111 per metric ton MT. For the period 1/1/2004 to 30th March 2004, the price would be 1189 per metric ton. For the period 1/4/2004 to 31st January 2005, the price would be 1689 per metric ton. For the period so therefore, accordingly, for the 5 years, the rate has been prescribed for supply of quantity of 2.50 lakhs metric ton to the petitioner. The contract was, my lord, that the OMC shall supply 50,000 metric ton of chrome ore to the petitioner. And in this manner, the petitioner is to get 250,000 metric ton of ore and a price. The dispute was on supply. In first order, direction was given. Then second order, the price was then disputed. Then, my lord, both the matter was taken by the Apex Court in the civil appeal, and it was an order and consent of both parties. So therefore, the Honorable Court said, instead of High Court exercising, we prepare the agenda, what shall be the price. So therefore, my lord, this order is only on consent by the Honorable Apex Court. Therefore, it is only to be implemented by the opposite party. Number 3. That is what my lord has said in the last para in my lord's order. Be that as it may be, my lord, next piece.
Yes.
As per the directions of Supreme Court for the supply of chrome ore 41% by the opposite party corporation to the petitioner, the chrome ore price shall be as under for the period specified against each, and opposite party corporation will put on record the details of the chrome ore supplied in accordance with the period and price as specified below. London Council of the opposite party corporation shall give details regarding supply of chrome ore within 2 weeks. My lord, that is good. Suddenly, my lord, they came off with a, then I, my lord, filed one miscase affidavit flag S, my lord, on 12/4/2009, stating therein that, my lord, they have supplied out of 2.50, 250,000 metric ton. They have supplied to the petitioner 1.5 lakhs, still balance of 1.45 metric ton is still lying with the OMC to be supplied. So therefore, my lord, the Honorable Court, in fact, by an order, another order, that order is 1910. That is order number 28.
That order simply asked them to file a reply.
Well, and
So
that
they were simply asked to file a reply, sir.
reply. And my lord, one more thing, my lord. In that 12/4/2019 also, my lord, I have enclosed 2 documents, annexes 2, 3 and 4, that pending the civil appeal, my lord, the opposite party number 3 said your money is lying with us for last 7 years, from 2007 onwards. Then, my lord, in that they stated that deducted an amount out, because my amount deposited with the excess amount was available with the OMC was 29,84,511. My lord, that affidavit filed on 12/4/2009 flag S. So as per that letter, they communicated to me a draft of 22,38,379.50 refund. Now they claim in the affidavit that you are to pay a balance amount of 2 crore somewhat. My lord, when the price has already been arrived on consent of both parties, which is recorded by the Honorable Apex Court, what is the question of revising a rate? My lord, my submission is this much. Let them supply the quantity balance at the rate already observed by the Honorable Apex Court in the order. That's my only.
Who's appearing for OMC?
Mr. Mahanti, I think.
Yes, Mr. Mant.
म्यूट करो म्यूट ही है ऑन करो ऑन करो.
Your Lordship, kindly see the order dated that 11/3, which my friend has shown to your Lordship.
Yes.
But the dispute is with regard to, kindly see the para 2. Page 2, last 2, Milord. Milord, he has taken the ore 1,04,000 metric ton, and Milord, he has paid less price, for which Milord, he has to pay Milord 2 crores rupees to us. That is the differential amount after the Supreme Court has fixed the price. That is what 21/2/2005 to 31/3/2006, then 1/7/2006 to 31/12/2006. But this Milord, we have given a revised invoice which he is not paying, Milord. Milord, the earlier court's order was. Milord,
No, but who will determine this dispute?
Milord?
He says he's not liable to pay this.
No, Milord, that is, Milord, he is, kindly see, your Lordship directed me to give a chart. I have given that chart. Today, affidavit dated 25/3/2010, filed in miscase number 13772. In that chart, Milord, I have given the invoice. And Milord, there, as per the Supreme Court order, this is what he has to pay. And Milord, earlier when Milord ore was supplied, it was stated without prejudice, subject to petitioner submitting an undertaking to the corporation as well as court, that it shall be liable to pay the balance differential amount in the event it is found due and payable in accordance with the result of writ petition. But that writ petition will be finalized by the Supreme Court, and Supreme Court has fixed the Milord price. Milord, that is that Milord in order dated 11/3. That is Milord the period for 21/7/2005 to 31/3/2006, 2236, and Milord 1/7/2006 to 31/3/3083. Instead, Milord, he has paid Milord only that 1989 for the first and 2236.
So today's prices have gone up or gone down?
Milord, it has gone up, Milord. I am Milord that at the relevant time, Milord, this is what the Supreme Court has fixed, and according to that, Milord, instead of Milord, kindly
you'll have to go back. Actually, you both have to go back to fixing the correct price then.
Milord,
if today you have to supply
No,
balance
today,
quantity-
today, Millard, that is not. No, it was for 5 years from 2003 to 2008.
Sir, I'm
The
saying
contract was
something-
over.
Mr. Mohanty, I'm saying something in your favor. I think you're immediately presuming we're against you.
Millard,
Ah.
I'm sorry, Millard.
So if today you have to supply the same balance quantity in 2022, it can't be at the same rate.
No, it
Correct.
can't be, Millard. It is at the auction price. Now, Millard, we are holding an auction.
Right.
And
yes,
Millard,
yes, Mr. Mahapatra, all time has flown.
My lord,
and Millard,
it is-
Millard, may
my lord,
may only one, Millard, 1 minute, Millard, kindly give me. Millard, that the differential amount I am claiming that is 2 crore 34,000 as per the Supreme Court order, because he has Supreme Court fixed at 2236. He has paid 1989 for second period. Supreme Court fixed as 3083. He paid at 2236. So this is the differential amount. But this, Millard, this comes to 2 crores.
One way to do it is both of you go for arbitration.
My lord,
On this issue.
This is a 2
My lord, I will
crore,
submit one
Millard,
point.
subject to your lordship has directed.
No,
that he
Mr.
has to pay-
Mohanty, OMC says he owes you that the petitioner owes you 2 crores. That's right?
Yes.
And he says, no, not only do I have not to pay 2 crores, I want you to supply the balance at the rate that the Supreme Court fixed.
No, Millard, your lordship can see balance cannot be, because at 2007 he could not take, and the
Right.
period was over.
No,
Yes,
my-
yes.
It's the wrong pack.
Supreme Court has never said.
My lord,
Millard,
my lord, they did not supply. They did
Supreme
not
Court has
supply.
never said with
That
regard
is
to
the reason,
supply.
my lord. The money was lying with them. Money was lying with them.
Millard,
for
I
5
will go through once again to the Supreme Court order. Supreme Court has never said with regard to supply.
No, my lord. Never,
It was-
never,
it was
never.
only
Both
price
of you,
fixation.
just a minute. So it's
Yes.
what is abundantly clear is that highly disputed questions of fact emerge, correct? There is no meeting ground.
Millard,
There is no meeting ground. There is only a disputed question of fact, correct?
Millard, your lordship, Millard, kindly, Millard, I will, one paragraph of the Supreme Court order I want to read.
No, we'll read any number of paragraphs, sir. The fact remains neither of you is going to agree with the other, correct?
We are not agreeing, but the law is correct.
So
Millard.
the
Law
question
is
is,
there.
so therefore the question is, these
Yes.
are complicated questions of fact. If you want this to be adjudicated in arbitration, it might help both of you. You please ask your respective clients, will you want to go for a time-bound arbitration?
Millard, kindly see from 2003 to 2006.
Mr. Mohanty, you better tell your client if they're interested in the 2 crores to go in for arbitration. Otherwise, this can go on and on.
Millard, I will take instruction.
Mr. Mahapatra.
My lord, same thing. Let my lord fix a date. I'll
But
take
Millard,
instruction.
he should secure it, because he has taken the goods with the Millard.
Lordship, I'll just
Millard, he
submit.
has
my lord.
for last
My
19 years, Millard, kindly see.
My lord, they hold my money for 7 years and refunded
No,
me.
it is not.
So what is the
It is
question
not
of they
at all.
supplying and I not paying?
Your lordship, kindly see.
Unfortunate, my lord. My money was
One
lying with them
paragraph,
from
your lordship, can see
2007.
of the Supreme Court order. One paragraph. It is
Lordship,
clear only.
kind
with
plan
price
How to go
fixation.
with the arbitrate. Say if you want this to be resolved, you better agree to arbitration. Otherwise, it will never get resolved.
My lord,
This will
also,
require
but it is-
evidence to be led. It will require documents to be shown. Some officer to be examined.
Millard, if your lordship will just give us 5 minutes, Millard, your lordship can resolve it. I'm sure, Millard.
Only if we hear only you and if we don't hear Mr. Mahapatra.
No, Millard,
If we hear only you for Mr. 5 minutes, Mr.
Millard,
Mohanty.
your lordship's indulgence for 5
Hear
minutes.
Mr. Mahapatra at all. No,
Millard,
we should
your-
not hear Mr. Mahapatra at all then.
Millard, I am seeking your lordship's indulgence only for 5 minutes.
At the end of 5 minutes, what will happen, sir?
Millard, if your lordship, Millard,
What
I'm
is your
sure.
guess?
Millard,
Let us do this. At the end of 5 minutes, what will happen according to you?
Millard, I'm sure if your lordship will just go through the brief only, I'll show to your lordship. Then your lordship will come back, Millard.
What?
Millard, if Millard, I will give Millard the orders and the High Court order.
Okay.
Supreme
Between
Court order.
you and us, what do you think Mr. Mahapatra will do?
Yes, Mr. Mahapatra will, Millard, after your lordship, Millard, read. And Millard, thereafter, Millard, Mahapatra, Millard, definitely, Millard, he will come to
He
Millard.
will completely surrender. He will completely keep quiet. He'll surrender. He will say, Mr. Mohanty is absolutely right, sir. Please dismiss
Millard,
my petition.
I never say so.
No. You don't have to say so. I'm just asking you what will happen at the end of 5 minutes.
Millard, I leave it to your
My
lordship.
lord, my submission is in 207. I will take instruction so far arbitrator appointment is concerned. That part, let him take, I will take instruction. Then third part, my lord, so far the supply of the balance quantity, let it come. That
Milord, supply, Milord, I will contest this.
Interim
There is no
directions, the
Milord.
arbitrator will pass. You say from the submissions made both by Mr. Manas Mahapatra, senior counsel for the petitioner, and Mr. Ranjit Mohti, senior counsel appearing for the Orissa Mining Corporation, bracket OMC. It is apparent that there are highly disputed questions of fact regarding the supplies of quantities of iron ore by the OMC to the petitioner in terms of the order dated 11th March 2019 passed by this court.
Iron ore,
Chrome. In terms of the order dated 11th March 2019 of this court, which in turn was consequent upon the order of the Supreme Court of India. Dated
13/9/2012. So, Honorable Supreme Court's order.
13/9?
2012.
2012. Full stop. The further fact that requires to be accounted for is that these questions had arisen way back in 2006 for quantities, no, in 2004, correct?
2003, man.
No, it commenced in 2003.
Yeah, dispute commenced sometime in 2003.
December 2003.
Regarding quantities of chrome to be supplied. Whereas now we are in 2022. So the further question is whether the petitioner can legitimately insist on supplies of chrome at the same rates that were determined in the order of the Supreme Court as on a tentative basis. Full stop. The court is of the view that all these complicated questions of fact, as well as interpretation of the order of the Supreme Court and this court, cannot be resolved in the present proceedings under Article 226 of the Constitution. Ideally, it should be resolved in arbitration, in a time-bound arbitration. Full stop. Paragraph. Both Mr. Mahapatra and Mr. Mohanty seek time for instructions from the respective clients whether they would be willing to go in for a time-bound arbitration on agreed terms of reference, incorporating both the claims and counterclaims of the parties. At their request, list on. One month is enough, sir. 21st April?
Yes, ma'am.
All right, 21st April.
Milord, your lordship, kindly, Milord, in this order, kindly say, Milord, my claim of 2 crores is the differential amount.
No.
Why should we quantify all that, sir? It may be even more with interest. Unless
No,
you know.
Milord, that your lordship.
Then I'll say you are foregoing interest.
No, along with the interest, your lordship, kindly say. Milord, your lordship.
Let's not foreclose anything. All claims, counter.
No, your lordship, kindly one line, kindly say. Because I claim, Milord, this is the differential amount.
Yes, sir. In your agreed terms of reference, whatever amount you want to claim.
Milord, in the order, Milord, kindly say, Milord, only not supply, Milord, it is my differential amount of 2 crores, Milord.
You have only said there's a lot of dispute. All right. This is not a final order, sir. Please. Yes. List on 21st April.
Special weekly list item 15.
But item 15, my lord. Item 15, I'm on.
Come to the mic and speak, sir.
Yes, madam. My senior in VC.
Yes,
But I'm appearing for the petition.
Yes.
My lord, first item, my lord, 8004 of 2004.
Yes.
Here I am for the petitioner, my lord.
Yes.
I have no instruction in that matter, hence
All
not
right.
pressed, my lord.
Counsel for the petitioner has no instructions, so he's not pressing the matter.
But fact remains, my lord. Your lordship may kindly see the last portion of the cause list, that is WPC 8282 of 2004. My lord, that was allowed by this honorable court on 27/10/2005. Review petition was dismissed. Then civil appeal, 2 civil appeals were filed, and civil appeals have been allowed on 20th April 2009 and matter has been remanded.
Anyway, you are saying you have no instructions at another
My
matter.
lord, on the earlier first one, I have no instruction. But on this 8282, that has been remanded by the apex court.
All right, you argue that, sir. Whatever you want to argue, you argue.
My lord, in that also, my submission may taken that I have also no instruction. And
Okay. 8282
my lord,
also no instructions. Okay. All right.
also the contempt matter, my lord, I have also no instruction.
Contempt also no
Contempt
instruction.
is infractions, madam.
All right.
No, yes.
After
Now
the
only
Supreme
what
Court
was left
sets
is
aside,
15984.
15984.
Right.
15984.
contempt, my lord, doesn't survive.
That's right. Contempt doesn't survive disposal. 15984. Yes, sir.
Lord, 15984, this matter, Lord, there are few dates involved in this case. Lord,
Right.
Your Lordship may just, I'll place those few dates. Thereafter,
Yes.
I'll go to what has happened in the meantime.
Right.
Lord, dates at 20th of March 1933, Kamala Devi, predecessor in interest of the petitioner, hereafter referred to as the lessee, was inducted as a tenant under the ex-intermediary in respect of the property in question and paid rent to the said ex-intermediary. 1952, the property in question vested in the state government under the provisions of the OE Act. The lessee, however, being in possession as a tenant under the ex-intermediary, was saved from the rigors of vesting and continued as a deemed tenant in possession of the property in question. Then OEA case in 1970, OEA case 4 of 70 was initiated against the lessee under section 5I of the OEA Act. Here starts the dispute. But 6/7/71, OEA collector set aside the leases in OEA case numbers 4 and 5 of 70 by common order, and the appeals challenging the same were consequently dismissed. The lessee filed OJC 882 challenging the dismissal of OEA case number 4, which was heard along with OJC 881 challenging the dismissal of OEA case. The other one. But 29/10/76, both the OJCs 881 and 882 were allowed, and the impugned orders under 5I of the OEA Act were quashed, and matters were remanded to the OEA collector for fresh disposal. Then 17/12/84, the lessee Kamala Devi died and the petitioner was substituted. The 24th in possession of the Honorable High Court and held the lease to be valid and referred the matter to Board of Revenue for approval of 7 acres of land in favor of the petitioner. Now, this is important. 2/11/1992, the lessees of both OEA 4 and 5 filed OJC so-and-so, respectively, challenging the action of the OEA authorities not settling the entire property in question in their names. These two writ petitions were heard analogously and were allowed holding inter alia that the order of the OEA collector were without jurisdiction and were non-est in the eye of law. It was also held that the lessee was deemed tenant under 8.1 of the OEA Act, and proceeding initiated under 5A of the Act shall be taken to have been dropped. That is Annexure 6. Then after running from pillar to post, as they did not accept the rent, I am before your Lordship in this present.
This is like execution proceedings.
No,
This writ petition is like an execution proceeding.
No, Lord, stand corrected, subject to your Lordship's correction. Lord, even after such dropping of the proceeding, as they have not accepted rent from me, I seek a mandamus directing them to receive rent from me. This is
have you been depositing the rent somewhere or no?
No, they are not.
That was not conditional.
No.
Even in a tenancy matter, we asked the rent to be deposited in court.
Yes, if that would have been there, only status quo order was granted by a Lordship at the time of admission. Lord, thereafter the real dispute starts. Lord, thereafter something happened during pendency of this writ petition. Lord, what has happened, Lord? After these two judgments were passed by the division bench of this honorable court, which I placed before, I'll show your Lordship, allowing, that means quashing the 5A proceeding on the ground that the leases were before 1/146. This your Lordship kindly note. The leases in question were before 1/146. So the OEA collector had no jurisdiction to go because 5I, at this juncture, I may invite your Lordship
to... Right now, what is there? Indian Oil Corporation Bank is there?
No, Lord.
Why is Indian Oil Corporation a party?
They have intervened because some part has been acquired in the meantime.
For what?
For by the government, state government.
No. Why, what has Indian Oil Corporation to do with it?
They want to put up a pump there in the acquired portion.
That's all over now. Status quo has been passed, right?
Yes.
What is the nature of the land? What is the nature of the land? Is it a vacant land?
Agricultural land. It was for agriculture purpose.
No. Where is it, sir? Where is it located?
Right next to the
Bhubaneswar.
other case. This is right next to the other. That day I was arguing that other matter. Lordship kept it for judgment reserve. Right next to Sainik School. The whole
Right
patch,
next to Sainik.
300 acres.
This is 300 acres. It's
No,
vacant.
this is not.
While
300
Leonard
acres.
Senior is arguing tip of the iceberg. One of the classic and biggest land scams of the modern era.
No. That is not the. There is not 300 acres. This is 53 acres. This is 53 acres, which we are concerned with.
No. Where is it located, sir? Heart of Bhubaneswar.
Bhubaneswar.
Only
Sainik
53
School.
acres in the heart of Bhubaneswar. Only 53
So where is the
acres.
question of agriculture?
No,
This is agriculture, sir, now.
That was in 1933.
So today what is it? What is the current status of this land?
Today lying like that, acquired because status quo.
No, lying vacant. Land lying vacant.
Yes, bro.
Anabadi and Juti Jungle. Your Lordship knows those judgments.
But thereafter, just your Lordship may bear with me. Thereafter, something happened which needs now, because this appears to be a simple case, rent is not being received. But what happened during pendency of the writ petition, two persons bought the suit property before your Lordship, which is in dispute before your Lordship. They purchased the suit properties from a fraudulent power of attorney holder. And they approached your Lordships saying that we are the beneficiaries under the sale deeds and we have claim title through Kamala Devi. Now, this writ petition was allowed. A review was filed, this review was dismissed. I was not a party to that. The matter went to the Supreme Court. Mr. Bagh was appearing in the first matter, which he is not pressed. What I did, I challenged this order, saying that it is behind my back. I don't know. When the matter reached the Supreme Court allowed the matter and remitted the matter, as your Lordship has heard, Mr. Bagh was saying. Now he has not pressed.
Now you have no contest from Mr. Bagh's client.
No contest from Big.
So you are a very happy man now, sir. Your client must be very happy today.
Very happy, very happy.
Then you should simply withdraw. You continue, you don't have to pay rent. You have some 300 acres.
No, not 300 minutes. I'm corrected. 53 acres.
53 acres. Very small part. Bhubaneswar city, 53 acres is a very small part of land, sir. I don't know what the value is. I don't know the number of zeros we'll have to add to that 53 for the value of that property.
I still haven't got a hang of the number of zeros that can be added.
It's all luxury litigation, Mr. Mohanty. Just imagine, you're not even paid 1 rupee rent. We got a stay in 97.
No, I bring to your Lordships only one aspect of your Lordship. The state is claiming under a 5I proceeding. Now, I was not party to the Supreme Court decision. Your Lordship may view that. The judgment passed by this Honorable Court, by the division bench, has not been challenged.
No, sir, Mr. Mohanty, what happens with passage of time is it all starts looking absurd. All right, 53 acres of some vacant land in Bhubaneswar, which is meant for agricultural purpose, for which no rent is paid. Just look at what is the justice of the situation now.
No, what will remain out of those 53 acres? Sainik School part has acquired. The Indian Oil Corporation has acquired.
No. So who is occupying this 53 acres now? Is it all still vacant? What is
Some parts are vacant. Government is contemplating to give it to some culture department. Some part is to be given to culture department. The other part is reserved.
What happens to these petitioners?
Manoj?
What happens to these petitioners? They want status quo in their favor. They have some orders in their favor.
This judgment has been, Manoj, this judgment has been not in terms, but it has been set aside by the Honorable Supreme Court.
No,
What
no,
happened?
This judgment has not been
Comes
set.
back. No, not the orders in his favor. That's not been set aside.
Not in this particular.
No. 21192 order and all has become final.
Yes.
What has happened here, my lords, your lordship will see. The stand of the state is that the whole thing is fraudulent. It's a product of fraud.
But you don't do anything about it. You allow all these orders to become final. You don't challenge them. Then you simply stand up and say in court it's all fraudulent.
No, lordship may tag that the other matter, that Harapriya Bisoy's judgment, my lord, that takes care of everything.
No, I don't go into, because that part of my litigation is over.
What happened was, my lords, what happened was, there are this 53 acres, my lords. First of all, my lord, this 53 acres could not have been, my lord, the whole thing vested in 1954. 53 acres vested, and how it vested, my lord?
Unless you get the whole thing nullified. See, you contest all these proceedings. I'm sure you've contested OJC 881, 882-74. Then OJC 2063 and 2057 of 92. You must have contested all of this.
In OJC 2063, the GA department was not a party.
Oh, no, same. It's a state government. Let's not now start dividing up into this department and that.
My lord, that has been taken care of. That question was raised in the Supreme Court, and Supreme Court takes care of it in Harapriya Bisoy's case.
How?
I've handed over. I'm passing on to your lordship.
Lord, with due permission from your lordship, Lord, so sorry to interrupt, Lord. He is sending those judgments.
No,
Please kindly, your lordship, have a look at page 50. The page 50 of the of your brief, of your lordship's brief, Lord. Page 50. That is the judgment of the division bench of this honorable court.
Dated 2/11/92.
2/11/92.
No, that's fine. No. I want to know whether this judgment has been spoken of in this Haripriya Bisoy.
Yes, ma'am.
No, this judgment has not been spoken of.
Let him point out, sir. He's trying to say it has.
The original lessee's name has come.
No. Para 4.
My lords.
Just read para 4 of Haripriya Bisoy. In support of the appeals.
In support of the appeals, Learned Counsel for the state submitted that the High Court has completely misconstrued the decision in OJC number 2063 of 1992. In the said judgment, the High Court had not returned any finding or expressed any observation with regard to the genuineness of the lease deed of 1933. The only issue before the High Court was whether the OEA collector had exercised its powers correctly under Section 5(I) of the Act. No further issue was under consideration of the High Court. Only the scope and jurisdiction of the collector and the Board of Revenue was decided. In the said decision, the High Court has not returned any finding that the late Kamala Devi was a tenant under the ex-intermediary before the vesting and on the date of vesting and was in possession of the entire disputed property. The High Court had erroneously recorded the said finding in the impugned judgment. Therefore, the High Court was in error by holding that Kamala Devi and thereafter her successor Kishore Chandra Patnaik were deemed to be tenants under Section 8(1) of the Act. It is pointed out that the proceedings in OEA case number 4 of 1970 were under 5(I) of the Act and not under 8(1) of the Act. Neither the order of the OEA collector in the OEA case number 4 of 1970 dated 24/4/89, nor the High Court's order in OJC number 2060 of 92 recognizes the predecessors in interest of the respondent as tenants under 8(1) of the Act. The OEA collector had categorically held in the order dated 24/4/1989 that the plea of the claimants that the proceedings to be treated as one under Section 8(1) does not hold water. The OEA collector was therefore conscious of the fact that there was no exercise of power under Section 8(1) of the Act but only under Section 5I of the Act. Further, the High Court was in error in its interpretation of Section 5I of the Act. The settlement of leaves in favor of the lessee under the first proviso to Section 5I has to be necessarily confirmed by a member board of revenue. One as this proposition has been affirmed in that other judgment of Brindavan Sharma delivered in 1993 Supreme Court, my lords. It has also been highlighted that the decision of this court in the state of Orissa versus Brindavan Sharma in 1995 Supplementary 3 SCC has been completely lost sight of. The conceptual difference between Section 5I.
So para 31 is important.
Yes, my lord. Thereafter, para 31.
Mr. Ramakant Mohanty, you'll have to read para 31 carefully. I'm asking you to read. Just read.
Yes, Lord. Yes, Lord. I'm holding the schedule.
In course of the hearing of the appeals, a query was made as to what is the effect of the order of the High Court in OJC number 2063 of 1992, that is whether it covers an area of 7 acres or the whole area of 53 acres of land. Learned counsel for the respondent submitted that in view of the finding that the order of the collector was indefeasible, obviously the right, title and interest of the respondent extended to the whole area. This stand is clearly unsustainable. The collector's order only refers to a certain inquiries made to confirm possession of only 7 acres of land. The High Court apparently had not considered this aspect. The High Court has also not considered the effect of alleged fraud and the fact that the relevant department was not a party in the proceeding before the High Court in OJC number 2060 of 1992. I think, my lord, this clarifies your lordship's doubt.
No, but what have you done? Come to this last but one paragraph.
Last
46.
Yes, that is the important paragraph also.
46.
46, my lords. In the background of the massiveness of the fraud, apparent fraud involved, effective and participative role of officials of the state cannot be lost sight of. Without their active and effective participation, manipulation of records, tampering of documents could not have been possible. The state would do well to pursue the matter with seriousness, to unravel the truth and punish the erring officials, and take all permissible actions, including criminal action against everyone.
So what has happened?
Manoj, the FIRs have been filed.
No. This is 2009 judgment, sir. We are in 2022.
FIRs have been filed. The state
is moving as slowly as it can. Correct?
No, possibly because of the pendency of the matters in
No. What did the Supreme Court ask you to do, sir?
Supreme Court had asked to make analysis.
No. Pursue the matter with seriousness to unravel the truth. Then what have you done in 13 years? Nobody prevented you from doing what you should do. You will be in contempt of the Supreme Court if you have done nothing. I'm making it very clear to you. We're going to reproduce today's order, this paragraph. Please tell whoever the officers involved are. They'll be in contempt of the Supreme Court if they do not give a satisfactory reply. Once the Supreme Court is characterizing this as a massive apparent fraud, then and wants you to be serious. If you're not serious, then you're obviously in contempt of the Supreme Court.
FIRs had been filed before the crime branch by the GA department.
FIRs will not do, sir. It has to go far beyond that. You have to find out who's involved.
It has to go right up to the top.
Wherever it has to go, sir, there has to be some action on the ground, not merely registering an FIR.
Lordship can direct the state to take immediate action on the FIRs.
No, I think you're mistaking what we are trying to tell you. If they've not already done it, they're going to be in contempt of the Supreme Court. Yes. You say one of the issues that have been highlighted by Mr. Ramakant Mohanty, learned senior counsel for the petitioner, is the non-implementation of the order dated 2nd November 1992 passed by this court in OGC numbers 2063 and 2057 of 1992. According to him, since that order has attained finality and it declared the petitioner lessee, bracket now represented by legal representatives, right? Bracket to be a deemed tenant under section 8 bracket 1, of the Orissa Estate Abolition Act. And it was further held that the proceeding initiated under Section 5(1) of the OEEA Act, 5I of the OEEA Act, should be taken to have been dropped, effect had to be given by recognizing the leasehold right of the petitioner, not only in respect of 5 acres of land, of the land in question, but the entire 7 acres of the land in question, but the entire 53.95 acres. Paragraph. Mr. Subir Palit, learned counsel appearing for the state.
No,
However,
GA department.
for the GA department of the state of Orissa, however, draws attention to para 31 of the judgment of the Supreme Court in state of Orissa versus Haripriya Bisoi, AIR 2009 SC 2991, which reads as under. Reproduce a whole paragraph. In fact, on carefully perusing the aforementioned decision of the Supreme Court, it is plain that the Supreme Court not only disagreed with the order dated 2nd November 1992 of this court, but also of the subsequent order dated 27th October 2005 in writ petition civil number 8282 of 2004, and the order dated 10/1/2007 in review petition number 13 of 2006, which were challenged before it in the aforementioned case. So the Supreme Court characterized the entire proceedings as a single quote, massive unquote, single quotes, apparent fraud unquote. Full stop. After discussing the detailed background facts and the provisions of the statutes, relevant statutes, the Supreme Court in para 46 issued the following directions. Reproduce para 46 paragraph. Today, when the petition was called out, it must be mentioned here that when the petition was called out today, counsel of the petitioner appearing for the counsel appearing for the petitioner in writ petition civil 8004 of 2004 and 8282 of 2004, bracket, which were required to be reheard by this court pursuant to the decision of the Supreme Court in state of Orissa versus Haripriya Bisoi, bracket, Supra, stated that he had no instructions to continue pressing those petitions. Accordingly, both those petitions have been disposed of as not pressed. Consequently, the connected contempt case number 1167 of 2006 has also been closed. Paragraph. Nevertheless, in view of the clear directions issued by the Supreme Court of India in Haripriya Bisoi Supra, it is incumbent on the state government to explain to this court what action it has taken in compliance with the directions issued by the Supreme Court in para 46 of the decision as extracted herein before. Paragraph. Mr. Palit on instruction states that an FIR was registered and criminal investigation was taken up. However, considering that the judgment of the Supreme Court is dated 20th April 2009, which is almost 13 years earlier, the court expects that much more should have, that there should have been much more progress in the matter beyond the registration of an FIR. Full stop. The Supreme Court's direction is very clear that the state should pursue the matter, open quotation, with seriousness to unravel the truth and punish the erring officials and take all permissible actions, bracket, including criminal action, bracket, against everyone involved, full stop, unquote. If the state has still not taken the above steps, it would appear to be in willful disobedience of the clear directions issued by the Supreme Court. Paragraph. In that view of the matter, the state in the GA department, the secretary GA department is directed to himself file an affidavit in this court explaining what steps have been taken by the GA department in compliance with the mandatory directions issued by the Supreme Court of India in Harapriya Bisoi Supra. The said affidavit should be filed in this court not later than 2nd May 2022.
Obliged.
List on 17th May.
Lord, may I pray one thing, Lord? Sorry to indulge, Lord. Your Lordship had referred that this Annexure 6, this decision of the Honorable of the Division Bench of this Honorable Court was under challenge in Harapriya Bisoi.
Not challenged. No, I've never said that. I've only referred to the 2004 decisions. I've said those two petitions were under challenge in the Supreme Court.
Two decisions were under challenge.
We have clearly said that, sir, but there's a discussion in para 31 of this very judgment.
And I don't dispute that discussion. But I wanted to show your Lordship that I don't come
this
under
very judgment has been discussed and it has been said it is all passed without actually appreciating the full facts.
Now your Lordship will hear that. Factually. No, the only thing your Lordship has fixed it to 17th. After 8th, I will be absent. Your Lordship will fix it to 8th.
We have it soon in the opening, sir. 22nd June.
Can I
22nd June. All right.
Can I make a small premise? So also, since the FIRs have been already filed, series of FIRs have been filed by the J department and same is pending for the crime branch. The crime branch.
You find out from the crime branch, sir.
Crime branch
you
should also.
Mr. Palit, this is something that I've never
I
understood.
understand, my lord.
As if the different limbs of the state can't talk to each other except
that.
through the court. You find out from the crime branch.
My lord.
Look at.
Special weekly list item 16.
May I pray, Your Lordship? This one is a society of the resident society. In the year 1989, they applied.
I think you'd have to talk louder, sir, into the mic.
In 1989, the petitioner society applied for land to implement some civil amenities in the residential area of Raulkela, 1989. Like Kalyan Mandap for library and other things. So that request has been accepted by the collector, and your Lordship can turn to page 14. That is later dated 17th January 1991.
Yes.
Yes, madam. A piece of government land measuring in 1 acre in the area 7 and 8 of Raulkela Town, Unity 42, a part of the earmark for the purpose of a commercial area in the master plan of Raulkela Civil Township is being considered to be temporarily provided to the resident association for constructions of Kalyan Mandap Center. The society shall furnish the resolution duly signed by its member, by the members of the committee to agree for the following conditions. The land shall always be in the name in the book of government. Necessary permission for construction shall be obtained by RRIT, Raulkela Regional Improvement Trust, and no deviations of the approved plan would be allowed. The planning and construction shall be.
You did not agree to all these conditions.
I have agreed, and then, my lord, this was placed before the land allotment committee. Lordship, kindly turn to the counter. They have annexed that document. Annexure B/5.
No.
I have agreed, my lord. That's
1 minute. Come to page 12. They charged a premium of 5,85,000.
That is exactly my case here. They in the sanction later, it was no premium has been fixed. Then the matter when placed before the LSC.
You mean you wanted this to be given to you free?
No, it is in the name of the government. I am not the owner.
Whatever.
Now,
you're committed to commercially exploit that land, collect rents, run a Kalyan Mandap. What are you saying? How can you expect to get this free?
These leases have been granted under the provisions of Orissa government.
And you managed to get a status quo from this court?
No, what I beg to submit, my lord, this is granted under the Odisha Government Land Settlement Act. I have filed an appeal before the government of before the government.
No. So, Mr. No.
And then it was forwarded to Revenue Divisional Commission.
Mr. Rathore, just tell us this.
My lord.
status quo order means you are in possession.
Yes, my lord, I was.
So you have taken possession even without complying with all these conditions.
My lord, it was never been asked for, and A and B. Well, Lordship, kindly see, this was asked in 1992. I have a right.
You're just a resident welfare association. You're sitting on some government property, and you're already running a Kalyan Mandap.
Well, that's what we have requested them for exemption at the free from premium, and they have already recommended it for free from premium. It's in the name of the government. It is not in our name, my lord. The entire thing is we are to only run it, and the exemption has been granted, my lord. The RDC.
What are you? You're some charitable organization.
No, my lord, it's a society. It has
nothing. What is this? You're given right to collect rents. No resident welfare association is a charitable organization. Let us not get into this kind of illusion, please.
My lord, may I interfere, my lord? We are the shop owners.
Who's the Rourkela Corporation? Who's
Mr. Mahapatra? He usually appears. My lord, what happened?
They are the most charitable organization, I must say.
Lord, still the
freely give everything away.
The entire thing is under the control of my lord government, my lord. 93 government had exempted the premium, my lord. That circular I have attached my case.
Sir, all of you, I think, have had a wonderful run. Okay, when was this stay granted? 2005, 17 years. You haven't paid a single penny, correct?
No.
Just imagine, sir.
Lordship can direct.
Just imagine what is the value of this property? How much? What is the extent of this property?
The property is being put to use as a Kalyan Mandap. Even as in today, we are not.
And only free marriages are conducted. You don't charge a single rupee for the Kalyan Mandap. Just look at the what has happened.
Lordship,
you got this land for nothing, paying nothing. You're running one Kalyan Mandap. Are you seriously suggesting in Rourkela Kalyan Mandap you charge nothing? Marriages are conducted freely.
I assume that they have a right to impose premium.
Please.
I have a right to.
What have you collected? If we ask you to file an affidavit to ask you to explain how much money you have earned in this Kalyan Mandap, it will far exceed all this premium.
There is an exemption notification by the government.
Sir, this is not for charity, sir. You're not a charitable organization.
No, to the society also it applies.
What is this? Why should the municipal corporation help a residential welfare association to earn crores of rupees like this?
Municipal association has nothing to do. It's only between the government in revenue department and the organization. Municipality has not. Municipality since not implemented.
So there's something seriously wrong. There's something seriously wrong with all of this. I'm sorry to say. I've dealt with matters of other metropolises. There seems to be something extraordinary happening here. Whether it's Bhubaneswar, it's Rourkela, precious property all given away like this. Somebody is exploiting and earning crores of rupees. And look at Rourkela Municipal Corporation, not even before us, not even filed an application to vacate all this.
And in 2005,
Mr. Mahapatra is normally appearing. May I prima Mr. D.K. Mahapatra is normally appearing.
For the Rourkela Corporation.
Mr. Mahapatra is appearing for the Rourkela Corporation. D.K. Mahapatra is appearing and he has undergone an eye surgery and is on accommodation for 15 days. My lord. He's 75 years old person, undergone an eye surgery.
Sir, what is happening is this Rourkela Corporation is not interested.
No, he has only over phone requested me.
No. His eye operation happened now. We are talking, this petition has been pending since 2005, sir. They got a status quo order on 26th May 2005, 17 years ago. They've earned several, maybe even hundreds of crores now. And they're insisting it should be given to them free, even today. Correct? Nothing should be charged. Isn't that your argument? They have no right to charge anything from you.
No, my lord, my case is simple, my lord. The exemption has been recommended to the government. The government is sitting, no final decision has been communicated. Now,
Sir,
we have
were
to
all
count
of
by
you,
that,
see.
because there is an appeal provision.
No,
and
no,
it's an appeal
one minute. The day you tell me that you have not earned a single rupee by running this Kalyan Mandap, we'll hear all your arguments. Please file an affidavit saying you've never commercially exploited this property. All you've done is everything is charitable, everything is free. People in Rourkela are having a wonderful time because of your Kalyan Mandap being the free Kalyan Mandap for the entire Rourkela city. In fact, I think people in Cuttack will start performing marriages in Rourkela if you say this in affidavit. They'll be very happy that one Kalyan Mandap in Rourkela is giving everything for free. If you are talking commercial exploitation, let us talk commercial exploitation. I don't know if state will have a policy like this. Just give Kalyan Mandaps to residential welfare associations, let them start earning money. It can never, that can't be the policy of the state.
Remains in their name. I have to put all these, the residents.
You file an affidavit, sir. How much have you earned by running this Kalyan Mandap? File an honest affidavit. How much tax have you paid on those earnings? What are the returns that you file? Are you filing returns as Residential Welfare Association?
I don't know what.
Why not? You are undertaking commercial. You are collecting rents from shops, letting out Kalyan Mandaps. Are you filing returns?
Minimal for maintenance and must not exceed the threshold.
Oh,
In any case, my lord,
please.
I am obliged.
We'll unravel everything now. You say, Counsel for the Rourkela Municipal Corporation stated to be unwell. Paragraph, the court directs the petitioner.
That is Rourkela Development
Okay, Development Authority. All right. The court directs the petitioner to file an affidavit in this court indicating giving the full details of its earnings from the Kalyan Mandap in question. When did you start occupying it, sir? When did you start occupying the land?
I think construction started by the petitioner 1993.
Great.
Out of his own fund.
Whatever. Since when have you been running it?
93.
Since 1993. Since 1/1/1994 till date. The petitioner will also disclose its tax returns filed since then, disclosing the income it has earned from running the Kalyan Mandap. If there are any other commercial activities, including renting out of shops on the property in question by the petitioner, it will disclose those details as well. The affidavit be filed positively on or before 25th April 2022 with an advance copy to the counsel for the other parties. Whom are you for, sir? Mr.
I have filed near about 17 cases. We had the shop owners on rent basis that one shop room.
You are paying rent to this welfare
Yes,
association?
we are paying rent to them.
Very good, sir. So you also disclose. The complete details could also be disclosed by the shop owners who have filed the companion petitions. All right.
The last quote one matter, my lords, WPC number 7863 of 2017, my lords. That is a different matter, my lords. It's a subroom allotment matter, my lords, of a different locality, my lords, by the RDA.
All right, just separate it out. 7863 will deal with that in a minute. The corporation can also provide the same details or file a reply to the above before the next.
Development Authority.
The Development Authority, sorry, RDA. All right. RDA versus RWA.
RDA.
I know, RWA versus RDA, I'm saying.
Yes.
List on 9th May, not 9th, sorry, 10th May, 2022. All right. Interim order to continue.
Yes, also direct the counsel for the RDA to sub some counter. In many cases, they have not sub counters. So we can file our regender in the meantime.
If any counter affidavit has been filed by RDA in the other petitions,
in other sub
copies be served on the respective petitioners within 2 days so that they can file a rejoinder before the next date. All right.
My matter is a different matter.
1 minute, sir. Will you just come to that?
The number.
Just so separate it out. What is your petition number, sir?
WPC number 7863 minutes, last but one matter. In the list.
7863.
7863 minutes of 2017.
Mr. Bokta,
My lord.
this RDA is run by whom? I mean, what is the official in the RDA? Secretary, director, what?
Secretary.
You just say the secretary RDA will remain present in virtual mode on the next date.
But Lord, 80
Please tell him that he is the most charitable person in this entire litigation. Although they are all claiming to be charitable, he is the most charitable. Yes, 7563.
7863 of
7863.
2017. Last but one matter.
Yes.
In the list.
Yes, sir. What is the issue here? Tell us.
Well, it is a subroom allotment matter. It is not connected with this present case. I have challenged the cancellation of allotment.
Tell us about the matter.
You'll also can see annexure 1 minutes.
Yes.
It's an advertisement minutes for allotment of the subroom minutes.
All right.
Advertisement for minutes for the bidding process minutes. I appeared minutes. I participated. I became the highest bidder minutes.
So this shop room is kept vacant since 2017, sir.
2017.
What is today's rate for the shop room? Where is this? Located in Rourkela again?
Yes, Lord. That has not been allotted in my favor, Lord.
No. So it will have to go for a fresh advertisement, sir. You participate now. You participate in the fresh advertisement. We are in 2022, sir. These are all commercial areas. It will keep going up and up. See, all our interim orders have economic consequences, right?
Yes. Here, Millers, I was the highest
We have
bidder.
to acknowledge that.
You'll also kindly see Millers annexure 4 Millers.
Yes.
I was the highest bidder, Millers.
Whatever, sir, now become an even higher bidder now.
They are after Millers.
Demonstrate your economic prowess. A new advertisement will be floated. You again become the highest bidder.
Okay. They have not allotted in my favor, Millers.
No. So no problem, sir. You have managed to stall it. The shop has been kept vacant for 5 years now. Nobody got anything.
Yes.
Neither you got nor anybody got. So let's have a fresh advertisement. You again become the highest bidder.
Then Millers,
You
my
say the
deposits may be returned.
petition had been filed questioning the auction process initiated by the Rourkela Development Authority in respect of a shop room adjacent to the Lions Hospital Market Complex, Civil Township, Rourkela. The petitioner claimed that he was the highest bidder, and yet the shop room was not allotted to him. But instead, even the successful bidder was not given. Successful allottee was not made a party. All right.
I am the successful bidder, Millers.
No. You were not given. Somebody else was given, right?
No, Millers.
Nobody was given.
No.
All right. While issuing notice in the present petition on 16th May 2017, this court had directed as an interim measure that one shop room should be kept vacant till further orders. That interim order has continued for nearly 5 years. As a result, that shop room in a commercial complex has remained vacant with no one getting the shop. Paragraph. The ground reality is that the present market value of the said shop has increased manifold. The rates at which the shop was being offered by way of auction would obviously have been increased by now. And Rourkela Development Authority, bracket RDA, would have to go in for a fresh auction. In that view of the matter, it is directed that steps for holding a fresh auction in respect of the shop in question be initiated and completed by the RDA within a period of 3 months from today. It will be open to the petitioner to participate in such auction. Clearly, the earlier auction is no longer valid, and that process will be brought to an end by virtue of this order. The petition is disposed of.
My deposits may be refunded. I have made the deposit.
If the petitioner is going to participate in the new auction, the deposits already made by the petitioner in the previous auction will be accounted for. All right. If he does not participate in the new auction, it should be refunded to him within 4 weeks.
Special weekly list, item 17.
Item 17 permitted to withdraw.
Council petitioner
On behalf of
seeks to
Mr.
withdraw his
Parker.
petition. Yeah, dismisses withdraw. All right, sir. That memo is taken on board. There's already a memo at flag X. All right, sir.
Special weekly list, item 18.
May I please? This is a matter relating to the sales tax revision case matter. Here is the question of law has already been framed. Page 4 of my brief matter. Whether on the facts and the circumstances of the case, the London Sales Tax Tribunal is justified in disallowing the adjustment of tax claimed by the petitioner on the ground as the tax has already been suffered at the time of purchase from a registered dealer inside the state while claiming in the successive.
What's the tax effect of all this, sir? What is the tax effect?
21,000.
Huh?
21,000.
21,000.
What is all this, sir? For
Hello, this is-
21,000, we leave the question open.
Hello, my lord, 21th now became with the interest is much more higher, my lord.
What will be high? Nothing.
So I given my lord, that's we
You
consider
had already paid 8,000,
small-
correct?
I have already paid tax. After I
8,000 you have paid. So only 13,000 you have to pay with interest. How much will it be? Maximum nothing. Nothing, sir.
My lord, I have already paid tax. When I purchase the material, pay tax. When I sell the material, I have not paid the tax. So the difference amount, property margin ought to be taxed.
So should we
I
actually,
cannot do double
should we
taxation,
write should we write one elaborate judgment for some 13,000 rupees?
No,
No, I'm seriously asking. Waste of time, sir. Really. You say considering that the insignificant tax amount involved in the matter, with the petitioner already having paid, that is rupees 21,689, and by an interim order, the petitioner of 16th May 2006, that is nearly 16 years ago, the petitioner having paid rupees 8,000 of the said amount. The balance amount therefore being less than rupees 14,000. The amount will still remain insignificant even if one were to account for the interest payable thereon. Consequently, while leaving the question framed by the said order open for a decision in some other appropriate case, this revision petition is disposed of.
Special weekly list, item 19.
in the sub item,
Sub item, sorry.
that is STRB 5/2006, my lord. Here is the case where the already question of law has been framed by this honorable court, that is on the order dated 5, dated 24/7/2006.
Two
Heard by
questions.
Counsel for parties, the revision filed with the assessee is admitted on the following question of law matter. Whether on the facts and in the circumstances of the case, the London Sales Tax Tribunal justified in confirming the enhancement of 7 lakhs made in case of search and seizure operation conducted by the department in an exhaustive manner against the detection suppression was at rupees 2,25,770 or irresistible information done by the London Sales Tax Tribunal at 1,80,000, which ought to be restricted to the extent of detection of suppression as per the report of the investigating authorities, either at 2,25,770 or inference drawn by the London Tribunal at 1,80,000. Conducting search due to exhaustive inquiry as per the settled position of law. We have only said that whatever amount they have detected, it has been restricted to that much amount. It has not been enhanced because it is a search and seizure case. Whatever amount they have found out, that is suppression.
No, that's only according to them, that's only tip of the iceberg.
So in that support, I have also the case law of the Orissa, same High Court, Honorable High Court of Orissa, that is the State of Orissa versus Fancy Motors Accessories Agency.
My lord, the file is missing. My lord, may I take it after lunch? I will go through. In the meantime, I will
All
go
right.
through your lordship.
After lunch. Pass over. All right.
Special weekly list, item 19.
Well, this is the second round litigation before lordship. Earlier, your lordship has directed the office to take a decision on the representation of the petitioner. The matter is regarding the construction of a septic treatment plant, my lord. on the Gochara land of the villagers, my lord, before adopting the
So
regeneration.
now we declined stay, sir, on 30/10/2006.
My lord.
While admitting this, issuing notice in the petition.
Yes, ma'am.
On 30th October,
30th October.
we declined stay.
Yes, your lordship.
So no stay for the last 16 years. A sewage treatment plant has been continuing.
My lord, only our grievance, my lord, without obtaining the consent from the pollution.
Sir, by now it has been operating for 16 years, correct?
16 years.
Ah.
My lord, 16 more, my lord, the earlier the proposal was in the year.
Sir, my arithmetic may not be very good, sir, but 30th October 2006.
My lord, I am in my lord case of my petitioner before lordship is Surgeons.
11775 of 2006.
No, my lord, this is not my case. My lord.
Sorry, sir. Sorry.
Sorry, my lord. This is not my case.
I don't know what is appearing. What we have is 11775, no?
Sir.
Sorry,
ma'am.
Who's for the petitioner in 11775? None appears for the petition. This was not prosecution.
Special weekly list item 20.
Item 20, I'm appearing for the petitioner, but I filed a memo, my lord, at the same time with some citations. But what has happened in this case, that the petitioner is a scheduled tribe, my lord. My lord, at the age of 8 months, he lost his father, and 10 years he lost his mother. He pursued his educational by staying with his paternal aunt, my lord. And thereafter, throughout his career, he was a first-class student. My lord, in the year 2006, he successfully appeared in the joint entrance examination and was provisionally given admission against a scheduled tribe seat in MKCG Medical College, my lord, Barampur. My lord, after having appeared in the first semester exam, just when he was about to appear in the second semester exam, the impugned letter was issued against him, my lord. My lord would see at A3, my lord. Annexure A by 3.
Yes.
Sorry, ma'am.
3, Annexure 3.
Annexure 3, my lord. At page 13.
In pursuance of the letter.
In pursuance of the letter dated so-and-so of the Director of Medical Education and Training, Orissa, Bhubaneswar, Mr. Durgadatta Jani, JE Orissa rank SC 29, provisionally admitted on 14/7/2006 into MBBS course against the reserve STC, who reported to have produced fake residence certificate, caste certificate. His admission is hereby cancelled, and accordingly, his name has been struck off from the college rolls with immediate effect by point clause 18 of the information brochure prospectus 2006, my lord. My lord, at this stage, I approach your lordship, and your lordship were kind enough to protect me by virtue of an interim order dated 25/7/2007, my lord. My lord, this entire process, my lord, of inquiry, my lord, this, as per Appendix 1 and Appendix 3 of the prospectus, I had to submit to the authority my residence certificate along with my caste certificate. My lord, that was procured from the Tehsildar and it was given to at the time of counseling. My lord, it was scrutinized at the time of counseling. The original certificates were scrutinized and I was given admission.
No, what was the protection?
Your lordship would see order dated 25/7/2007.
My God. So this is MBBS course, sir?
Yes, my lord.
So you completed the whole MBBS course?
Now the entire course has been completed.
No, and you've gone, degree also has been awarded?
Degree, my lord, I have.
And you're practicing as a doctor?
I'm practicing as a doctor.
My God.
My lord, my respectful submission is that the entire process of cancellation of certificate, my lord, your lordship's Honorable Apex Court has held in the case of Kumari Madhuri Patil, my lord, that it cannot be done by any other committee but by the committee appointed by the state. Your lordship would kindly see, I'm relying on the judgment, my lord. 1994 6 SCC, page 241, my lord.
Kumari Madhuri Patil.
Yes, my lord. Your lordship may kindly turn to para 13 of the judgment, my lord. Paragraph 30, my lord. The admission wrongly gained or appointment wrongly obtained on the basis of false social status certificate necessarily has the effect of depriving the genuine scheduled castes or scheduled tribes or OBC candidates as enjoined in the Constitution of the benefits conferred on them by the Constitution. The genuine candidates are also denied admission to the educational institution or appointment to the office or post under a state for want of social status certificate. The ineligible and spurious persons who falsely gain entry resort to dilatory tactics and create hurdles in completion of inquiries by the scrutiny committee. It is true that the applications for admission to educational institutions are generally made by your parents, since on the date, many a time the student may be a minor. It is the parent or the guardian who may plead fraud, claiming false status certificate. It is therefore necessary that the certificates issued are scrutinized at the earliest and with utmost expedition and promptitude. For that purpose, it is necessary to streamline the procedure for issuance of social status certificate in the scrutiny and their approval.
Anyway, so there has to be a separate committee.
Yes, madam.
This has to be done at the earliest, not like this. When you finish your whole degree course, you just
yes, my lord. And this
practicing as a doctor now.
My lord, I have in 2003, my lord, I obtained the certificates from the same Tahsildar. There was no dispute. 2005 obtained the certificates from the same Tahsildar. There was no dispute. But subsequently, my lord, when the entire thing was triggered, my lord, because I sought financial help from the state because I was scheduled tribe and I'm pursuing an MBBS course, my lord. The government directed the collector to cause an inquiry. The collector in turn directed the Tahsildar to cause an inquiry. The entire inquiry was conducted behind my back without giving an opportunity of hearing, my lord, which is also in violation of the statutory rules, that is Orissa miscellaneous certificate rules. But this, as per the judgment, my lord, post 1994, if at all the certificates needs to be scrutinized to find out its genuineness, it has to be done by the committee itself and nobody else has the power. And the paragraph 13.4, 5 and 9 are important in that respect. But this judgment of the Supreme Court has been also referred in the subsequent judgment. Your lordship may kindly see paragraph 17 and 18 of the judgment with Collector Bilaspur versus Ajit P. Jogi and others.
No, that is, you see, all this is for inquiry into whether you actually belong to a certain caste or a tribe.
Absolutely, madam.
But producing a fake certificate is a completely different ballgame, sir.
No, my lord, with great respect, my lord, so far as the certificate is concerned, my lord.
No, there is an affidavit of the Tahsildar. Let's read
yes,
that.
Your lordship may kindly see the Tahsildar, whether even the rules has been followed or not. Lordship may kindly see the affidavit of the Tahsildar.
Look, that cancellation is not under challenge here. Cancellation of caste certificate
that is correct, but
is not the subject matter.
See the affidavit of the Tahsildar. Before your lordship may kindly turn to Annexure E by 7 at page 29. But this is the basis on the basis of which the inquiry was conducted. And why this letter was written to by the collector to the Tahsildar, lordship for a moment kindly turn to the affidavit of the DA Minty, my lord, Annexure A by 2 at page 5. But because I applied for financial help, subsequently the government directed the collector to cause an inquiry. Your lordship may kindly see Annexure E by 7 itself. I'll just read out, my lord. In enclosing herewith a photocopy of the nativity certificate and caste certificate issued in favor of Sri Durga Jani of village Mandragoda, I would like to please conduct a detailed inquiry into the affair and submit your report within 7 days. My lord, by this time I was already pursuing my course in the college itself. I was no longer available in my village, my lord. The veracity and the circumstances leading to issue may please be meticulously looked into, since the person is said not to be residing in the district now. But thereafter, lordship would see
Let's see annexure F7,
Yes, my lord.
29 July
My lord,
2006.
for a moment, my lord, your lordship may kindly see annexure B by 7 at page 19. That is the inquiry which has been conducted by the Tehsildar. The order sheet, my lord. Annexure B by 7 at page 19, my lord.
Yes.
My lord, 29/7/2006. This is pursuant to the collector's order. I visited the village Mandrakuda along with the RI Dudhari and the RI Simliguda of Dudhari Circle, conducted local inquiry relating to the sons of Bisu Jani, Jambi Jani, sons of Rupa Jani by caste, Kandha. I came to know that Bisu Jani died about 20 years back, leaving 4 sons, namely Dora, Sana, Narayana, and Lukku Jani. All of them are staying at Mandrakuda. They deny to have known Sri Durgadatta Jani. I found nobody in such name residing at Mandraguda, nor in the neighboring village. Also, statement of the same, some of the villagers has been recorded in my presence. They stated that they do not know such person, namely Durgadatta Jani. From the above, it is evident that the nativity certificate issued in favor of Sri Durgadatta Jani by my predecessor, by RMC number of 2003, and subsequently the same certificate issued in 1065 of 2005, are fake. Both the certificates require cancellation. With the observation, the nativity certificates issued by RMC number 1017 of 2003 and 1065 of 2005 are hereby cancelled under Rule 7 of the OMC rules. Cancel it, but without having afforded an opportunity, they refer to Rule 7. May I, for a moment, read out Rule 7 itself, my lord? Rule 7 says,
yes,
of the Orissa miscellaneous certificate rules, my lord, review of orders.
Yes. Rule?
Review, Rule 7, my lord.
Rectification of clerical errors.
No, my lord. This is 1984, my lord. Now 2019 has come into force, but at that point of 1984.
No, one minute.
Orissa miscellaneous certificate rules 1984.
There's a 2017 rules here.
17 has also been repealed in the meantime. 2019
has come into force.
Well, I am passing my book.
But this is of year of 1984, my lord.
Right
Yes,
side.
Rule 7, review of the orders.
Review of orders. Notwithstanding anything contained in these rules, if it is revealed on subsequent verification or otherwise that the certificate should not have been granted or the contents thereof require modification, the revenue officer or any officer superior to him in the revenue administration hierarchy shall be competent to review the orders granting the said certificate, and after giving the person concerned an opportunity of making any representation which he may wish to make or pass such orders as he deems just and proper in the circumstance of this case. But they're referring to Rule 7 while cancelling my certificates, but they do not think it's appropriate to have heard me, my lord. Your lordship would see now at page 31, my lord, but already on 29/7/2006, they have just taken a decision to cancel the certificates. But subsequently, my lord, on 21/8/2006,
2013, he's managed to get. See, you've given him the compilation.
my lord.
Have you given him the compilation?
Yes, my lord, I've given him the compilation.
You got the compilation. Kindly see last 2 pages of that compilation, sir. He's managed to get another caste certificate in 2013. And look at the next page. He's got a nativity certificate. All in 2013. 10 June 2013 by the Tahsildar. How did they issue this, sir? When the case is pending here?
So this is by a different Tahsil. This is by Tahsildar Simileguda. Earlier that was Nandapur Tahsil, Patangi.
Probably the Tahsil must have changed.
But the village is the same thing, Mandarguda.
Yes, my lord.
Mandarguda is in PS Sibiliguda.
Yes. I have to obtain instruction how
How is it possible?
Yes.
And no one is interested, sir. He's completed his MBBS. He's practicing as a doctor now.
A doctor in the state itself, my lord.
He's employed by the state
Yes, my
government.
lord. Employed with the state government, and
Brilliant.
Lord, the fact remains that I am a scheduled tribe, and with great respect, my lord, as per the Honorable Apex Court judgment, it can be only be verified by the committee. Now in 2012, or 1994, the judgment was passed, but 2012, the state has come up adopting the guidelines issued by the Supreme Court. And your lordship will see in subsequent judgment also, Honorable Apex Court has categorically held that it can be cancelled only through the scrutiny. And the last judgment, my lord, the Honorable Apex Court has held that so far as appointment is concerned by virtue of a fake certificate, it should be viewed seriously. But so far as admission is concerned, in view of the fact that a lot of money has gone, public money has gone to the towards the education of the child, and the fact that he is now.
So you're in a government hospital in Berhampur.
Berhampur, right? Same hospital, MKCT, but I just Google search, my lord. I couldn't trace out the client. I just Google search, but I found out that he's employed with MKCT Medical College as an assistant professor.
Assistant professor.
And throughout his career, he is, my lord, academically is brilliant.
Yes, Mr. Mudli. You want to get instructions on how this happened?
Yes, ma'am. I have to obtain instruction.
Mr. Rajit Roy has placed before the court a compilation of documents which includes a caste certificate dated 10th June 2013 issued in favor of the petitioner, recognizing as belonging to the Kandha scheduled tribe, and a resident nativity certificate of the same date, certifying that he is a resident of village Mandarguda in PS Semiriguda. So both these documents were obviously issued during the pendency of the present petition. Paragraph. Additionally, Mr. Roy informs the court that pursuant to the impugned order dated 26th April 2007 passed by this court, the petitioner proceeded to complete his MBBS course, obtained the degree, and is right now an assistant professor in the MKCG Medical College in Berhampur under the state government, run by the state government.
And so far as
Mr. Mudri states that he will seek instructions and file an affidavit as to the above circumstances.
But so far as the employment part is concerned, factually I may be incorrect because I just found it from Google that he's employed.
It's okay. You say, and it is learned that on both the above aspects. On or before 27 June 2022.
27 June.
He has to file an affidavit. Response thereto, if any, be filed before the next date. It's on 20th July, 20 July.
Special weekly list item 21.
May I please your lordship? My lord, the Amrutamani property of Lord Jagannath, and it was in the name of the Marfadar was the Uttar Parsha Matha, which was established in the year 1368 at Puri, and the property in question. Kindly see para 4, page 4, para 4 of my writ application, where in the year 1931, as per Annexure 1, the lands were recorded in the name of the Matha, the Marfadar, that is Jagannath Mahaprabhu Marfat Mahanta Govinda Ramanuja Das in Khatar 59 Uttar Parsha Matha. Then, my lord, the RR was issued in the year 1991, on 13/3/1991, Annexure 2, where also the land were recorded in the Marfaddarship of Govinda Ramanuja Das of Uttar Parsha Matha. Then, my lord, when the way of proceeding, the land was vested to government, then my lord, under 6(7) of the Orissa State Abolition Act, the Matha filed an application that was registered as OA case number 704/74, and but OA 74 after several years, no order was passed, for which again the petitioner in the year 1989 filed another OA case, that is 846/89, where the notice was issued and had Annex 4, my lord. My lord, but without passing an order in that case, when it was delayed, on inquiry, petitioner came to know that the land on his back, they has been recorded by the Annex 5, the Marfandarship has been changed in his back. Though 69 to 1 of the Hindu Religious Amendment Act specialists, that a notice is required to be issued to the person concerned, who is whenever the trustee, specimen 69. Whenever the trustee or any religious institution is sued in any civil or revenue court in respect of any property belongs to or be given or endowed for the purpose of any religious institution, notice of such suit shall be given to the by the court concerned to the commissioner at least a month before commencement of the hearing. But so no such notice has been issued. My lord, at the same time, when by the Annex 5, it is found that several OA cases has been instituted by the Opinion 2 in the OA case number para 9, my lord, paragraph 9. In the OA case number 92/92, 90/92, 103/92, 103/92, and 7/92, the lands have been recorded, and a portion of the land, the opinion has been sold by opposite partner 3 and 4 to opposite partner 6.
So kindly deal with the counter affidavit filed by the.
Yes.
By the deity.
My humble submission is that in similar case, your lordship has remanded the matter.
No. Let's read this.
Yes, counter affidavit. Yes, madam.
Wow.
Which paragraph?
Yes, please. No, please read. 1 minute. Please read, sir, para 7.
Return to the arguments made in paragraph 2 of the writ petition, the deponent humbly submits that the sued property is the absolute endowed Lord Jagannath Mahaprabhu Vijay Puri, the then Mahanta of the Matha, was appointed after that. That's correct. That question is correct, my lord. My lord, kindly see the.
You don't read the whole paragraph, this whole problem.
No, I'm reading, I'm answering that.
No, you first read the whole paragraph, then you answer.
The Mahanta of Matha was appointed after that only to manage the property. Lord Jagannath Vijay Puri is the sole beneficiary, and the Mahanta, whose name was recorded in October 1931 Arwar, had no pecuniary interest over the property in dispute after enactment of the Jagannath Temple Act 1954. The administration of the and governance of the temple and its endowed vested to Jagannath Temple managing the committee as per the section 5 and 30 of the said act, and the Marfadar lost their right to manage or deal with any other manner in respect of the property endowed in favor of the Lord Jagannath Mahaprabhu Vijay Puri. The recording of the name of the petitioner is Marfadar Lord Jagannath Mahaprabhu in the settlement are published in the 1991 was wrong and illegal, and does not entitle the petitioner to claim any right, title, and interest over the disputed property. The trust estates of Lord Jagannath Mahaprabhu vested in the state government free from all encumbrances on 18/3/1974, and the property in disputes has been settled under Section 6(7) of the OE Act in favor of the Lord Jagannath Puri with the Temple Managing Committee as Marfudar. After this such settlement, the opposite parties, as per the provisions of the uniform policy, allocated the disputed plots to opposite party number 1 and 11, and they are the possession of the respective areas purchased by them. The petitioner has no legal right, title and interest over the said land, has no legal right to challenge such allegation. That position, my lord, I am very much aware of it. Mind kindly see the Siddhamata case where the Supreme Court has passed the order on the basis of which they are placing taking the methodology. In the last paragraph, the Supreme Court has held, we make it very clear that the striking down of the first part of the proviso to Section 200 of the OA Act 951, as mentioned above, and passing of the notification referred to supra will be prospective, and these judgments shall not be applicable to the settled claim of the claimants hitherto under the provisions of the OE Act 951 in so far as the lands of the Lord of Jagannath Temple Puri is concerned. My lord,
stand, Mr. Mohanty, he says Siddhamata Trust matter.
Yes, my lord.
It was clarified that this vesting is
prospectively. It is prospectively. But here they are only depending upon the 1991 record of right, which neither creates title nor extinguishes the same.
They don't have any document to show they were there since 31.
No, that is
yes,
not.
Yes, my lord. I filed the document.
The amendment of the act is also.
Annexure 1 is the document of the first document, and the second document is Annexure 2. 91 document is Annexure 2, and the third document is Annexure 1. My lord.
This is ROR of 31, sir.
Yes, ma'am. ROR.
Was this there before the authority?
Yes, that it has been clearly written by Govinda Ramanuja Das.
Huh?
That Govinda Ramanuja, who is the Mahanta of Uttar Pradesh Matta, his name has been described in the.
No. Was this there before the authority, sir? This document, or is it being produced for the first time here?
No, my lord, I could not get a chance to produce that document because, my lord, from the beginning, I clearly narrated that that I filed 2 OA cases. That first is that 704 by 74 by para 6, my lord, and the second was filed in the year 846 by 89, and they have registered, they have issued notice, but they have not had, and no order has been passed on that case. But on my back, in the year on the application of the of 2, another OA case has been registered in the year 1992, 92. And they have passed the order without intimating me. I'll submit all my documents before the authority if I'll get a chance, my lord.
All right, let him do that, sir. All right, the petitioner will produce all the documents in its possession before the opposite party number.
OA collector.
Administrator, sir, chief administrator. No, it will be before the chief administrator because no collector Puri is not made a party.
No, the property is situated in Cuttack, I think.
Property is situated in Cuttack.
Yes, ma'am, Cuttack.
Before the collector Cuttack, who will give a hearing to the full stop if such documents are produced not later than 2nd May 2022, the collector will give the petitioner a hearing, examine the documents and pass fresh orders.
Keeping in view the Siddhamata's decision.
Keeping in view the decision of the this High Court. What is the citation, sir?
No, sir, this is of Honorable Supreme Court.
Oh, it's the
Sri
Supreme
Jagannath-
Court, correct.
Sri Jagannath Temple Managing Committee versus Siddhamata and
Sri
others.
Jagannath Temple Managing Committee versus Siddhamata.
2016-1 OLR 209.
209. The order shall be passed not later than 2nd September 2022 and be made available to the petitioner not later than 9th September 2022.
My lord, the collector may be directed to hear the temple administration also.
Yeah, hearing the petitioner and the temple administration.
Because they have got a claim over the property.
Yeah, order will
Actually,
be made
they are
available
the-
to the parties not later than 9th September. Sorry, yeah, 9th September 2022. Till then, the status quo as of today shall be maintained. The petitions are disposed of in their terms.
Special weekly list item 22.
There are item 22. Several matters, madam. In 21, there are several matters. In this, which several matters are there?
Sorry, sir?
In item 21,
Ah.
a series of matters are there.
Oh, all right. Tell us.
I am not in the second matter, 18,087 2004.
You're not there in that.
No, I'm not. I'm in the next matter. I am there.
Sorry? You're only in the first
The
matter.
second one is Mr. Pal's case.
Third, I am also in third.
Sorry, you're in the third.
Yes, ma'am.
9199.
Yes, ma'am.
So only 9199. You say 7004 1887. All the remaining, you say none appears to the petitioner dismissed non-prosecution.
No, all the revenues. I mean, 9199 2007, and also in 11123 by 2007, and all other matters except last one. Last one and second one.
Except the second one, all other matters, Mr. Jena is appearing, I think.
Yes, ma'am.
All right. Second one, you say none appears to the petitioner dismissed non-prosecution. All other numbers. All right.
Special weekly list item 22.
Item 22, I may be permitted to withdraw to file a suit.
Counsel petitioner seeks leave to withdraw this petition with liberty to file a suit in accordance with law.
I'm appearing for the law Lingaras, my lord.
All right. Disposed of is withdrawn with liberty paid for.
Special weekly list item 23.
I mean, pardon my lord. In 21, there are a series of matters and all are different.
So you should tell us what is this, sir? We keep waiting. You're not telling us all this.
No, I'm telling you. Then my lord, the item note WPC 9199, the similar case. That too, but the Tahsildar is of Tahsildar Satyavadi.
No, the collectors are different, I think.
Different.
That your lordship can direct to check the records, and only the collectors are different.
All right.
In some cases Puri, some cases Cuttack.
All right. You have to look into each petition for which is a collector. All right. All right, sir.
Special weekly list item 23.
Yes, item 23 is all the four STRE issues 44, 45, 46, and 47. These four registrations arise out of the common order passed by London Tribunal Head Annexure 6 minutes. And the question my lords may kindly refer to minutes page 14. One question which is already covered by your lordships, at least in two judgments. My lords may kindly see question number small a at page 14. Whether in the facts and circumstances of the case, the taxing authority can sit in judgment over the eligibility certificate issued by the competent authority as per the notification dated 16/8/90 notified under section 6 of the OST Act. Because referring to that Bhadilal judgment, my lords can remember in Akbari Continental's case and this Bajrangi Lawyer's case, my lords have decided.
Only this morning we passed another order.
Because I have given copy of two judgments of a lordship.
Or same order as in the first, I think it was first item or second item?
It was item number 10, Millards.
Item 10. All right. Sorry. In view of the judgment of this court, dated 20th April 2021 in STREV 28 of 2006 bracket Messrs. Bajrangi Bali Bajrang Bali Wire Products Private Limited, State of Orissa.
Para 17.
Yeah, para 17, the questions framed by this court. Have they already been framed or we have to frame? All right, admit the following questions are framed A and B. The question framed is answered in favor of the SCC and against the department by holding that the competent authority is bound under the sales tax. The taxing authority is bound by the eligibility certificate issued by the District Industry Center in terms of the notification dated 16th August 1990 under Section 6 of the Orissa Sales Tax Act. Semicolon. It is further question B is answered again in favor of the SSC and against the department by holding that the fixed capital investment during the period between 1st December 1989 and 31st July 1992 is the period during which the industrial unit should be set up for grant of exemption under IPR 89. The petition is accordingly disposed of. There are two matters, right?
Four matters.
Four
All
matters.
four same order. Yes.
All right. In view of the order passed and above, these revision petitions are disposed of in the same terms.
Special weekly list item 24.
None appears. Dismissal not possible.
Special weekly list item 25.
Both 25 and 26, they arise out of this common order of the tribunal notes.
Right.
This matter, my lord, I may be permitted to place on behalf of Mr. Mishra. Notes.
Yes.
So here, my lord, the questions of law by order, the lordship's, my lord, order dated 5/2/2008, my lords. Lordships have been kind enough to.
Subject to your paying 1,50,000.
Months.
That has been paid.
But I think it must have been paid, my lord. Otherwise, it could have been recovered, my lords. I do not, frankly, I do not have that instruction, my lord. It's a very
All
old
right.
matter. So, lordships have referred to all the questions of law at page 10, my lords.
10 and 11.
Page 10 and 11, my lords.
Six questions. No, 7 questions.
7 questions.
My God.
So, I'd only place question number A, my lords. Whether on the facts and the lordship got it on page 10.
Jurisdiction. Right.
Whether on the facts and circumstances of the case, the tribunal is justified in holding that it has little scope to examine the assessment record, particularly when the question of jurisdiction.
Mr. Kare will continue after lunch.
Much. Framing this question is, my lords, reasons to, my lord, it's this 12-8 proceeding was under a complete change of opinion, my lords. And for that, if your lordship would permit me to go question-wise, I just take your lordships to the assessment order, my lords. The lordship would kindly turn to running page 14 of the assessment order, my lords.
Yes.
Here, the petitioner was initially assessed under 12-4. There's a regular assessment, my lords. Basing on an audit report and a report from the inspector of sales tax of the circle, he gives again a notice under 12-8 and proceeds against a 12-8, almost reviewing his own order under 12-4, my lords. Here, the main question was, my lord, and your lordship have also dealt with that matter. It was a question of supply of ballast and laying of ballast by the railways, my lords. The question was whether my price at the crusher point or my price at the stacking point would be considered, my lords. Your lordships have held, my lord, that since it's a composite contract, my lords, it begins from the crushing of the boulders to form the ballasts, then stacking it, and then the laying of the ballast wherever the railways want, my lords. The payment by the railways, even though after it was spread over, the ballast was spread over, will not exclude the petitioner from claiming the transportation charges from the crusher point to the stacking point, my lords.
Okay.
So I'll just place for the, so far as the first question is concerned, running page 14, my lords.
Yes.
May I please paragraph 2? It's an unnumbered paragraph 2, my lords.
In the adverse report.
It begins with that the dealer's business activity.
Right.
That the dealer's business activities can broadly be divided into two categories. That is, the dealer executes works contract and has a stone crushing unit where he supplies ballasts and crushed stones of different specifications to railway authorities mentioned above. During the year 92-93, including his own construction work, he has supplied stone ballasts as per voucher number so-and-so, so-and-so, so-and-so to the Talcher Sambalpur rail link project and received rupees so-and-so to a supply of stone ballasts. This amount is exclusively for the supply of stone ballasts and his total GTO returned at rupees so-and-so. The dealer has been assessed under section 12(4) of the OST Act on 29/2/1996, and the dealer's contention that at this stage that the above amount towards supply of ballast is part of the works contract and taxable at 4% has been upheld at that stage by the assessing officer. Now, in the report of the Circle IST, has suggested to treat the above supply of stone ballast as a sale and in view it separately from that of the works contract and tax it at 12%. So this was a triggering point, my lord, for initiation of the proceeding under 12(8), my lords. Then, my lords, he has also said in the last paragraph of that, in addition to this, he also receives an AG report, the last paragraph, my lords, of that same page. The AG audit has raised objections against the dealer against the regular assessment of 12(4) of the OST Act by number so-and-so. The objection raised by the AG audit is similar to the objection raised by the city IST, my lords, which has been exhaustively discussed in the foregoing paras. The audit has objected to the fact that the supply of ballast has been treated as a cofactor of works contract and has been taxed at 4%. According to the audit, the sale of ballast should have been considered separately from works contract activities of the dealer and should have been taxed at the rate of 12%. In view of the discussions made above and precedents set by the Honorable Supreme Court of India, and objection raised by the AG audit is genuine and therefore is upheld. So my humble contention, my lords, had this been a case of a suo motu revision by the commissioner, my lords, it can be visualized that the commissioner has the power for a suo motu proceeding, my lords. But having completed a 12(4) assessment, my lord, only on basing on the AG's audit report, he can't change his opinion, my lords, and maintain a assessment order under 12(8), my lords. And your lordships have referred to Kelvinator's case, my lord.
That's for the income tax.
Income tax, but the wording of these two, my lord, is the same, my lords. If your lordship would take up section 12(8) of the OST Act, my lords.
No, but Mr. Kar, that question was, it had to be based, there had to be materials which form the basis of a...
Correct, my lords. There was one, my lord, there was no material because unfortunately the tribunal did not call for the records, which was examined by the first appellate authority while allowing my appeal in the first appeal, my lords.
Oh, here your first appeal is allowed.
My first appeal is allowed. The department went up to the tribunal in a second appeal, which again confirmed the assessment order, setting aside the first appellate order.
No. So if you look back at the assessment order, it is not that it is not based on material. The material being twofold. One is the Circle IST's report.
My lords.
The other is the AG audit.
My lords.
So these form the material on the basis of which he's come to the conclusion that the assessment requires to be reopened.
But my humble contention, having concluded on these materials on my examination of my contracts with railways, if you are, the assessing officer has formed an opinion, my lords, and rightly allowed my 12(4) assessment, my lords, he cannot turn back on these materials
No, for 12.8.
12.8, my lord, the test is, my lord, there can't be any change of opinion. That will be my humble submission.
No, no. If there is material to persuade him to come to a different conclusion, what happens?
My lord, material, my lord, if there is such a material, my lord, it should have been at the relevant point of time the Assistant Commissioner of Sales Tax who has a suo motu power, my lord. If he is in receipt of an audit report, my lord, or if he is in receipt of a report from the Circle IST, my lord, Section 23, my lord, deals with powers of suo motu revision, my lords.
No, that stage, let us say, either it's not reached, or in the sense it has not been exercised.
My lords.
They are only on 12.8. For
True,
triggering 12.8.
So for maintaining a proceeding under 12.8, my lords, there can't be a change of opinion. There's in fact, 12.8 says reasons to believe and for any other reason, my lord. These are the two tests. And so far as reasons to believe and for any other reason, they have been said to be held to be parametry, my lords. My other submission, my lord, is
no. What happens here procedurally under 12.8, there must be a record of proceedings saying reopen assessment, is it?
But it's only a one-liner, my lords. Peruse the report, initiate proceeding.
Okay, and then in the reassessment proceedings, he gives you a copy of the audit report?
No. He confronts. He confronts.
Okay.
So what
you don't know what the contents of the audit report is?
No, the contents, my lord, is they say, my lord, in the 12th proceeding, they say it's a works contract, and the transportation, 67% is supply. The other part of it is works contract, and it charges me 4%. In the audit report, they say no, it's a supply of ballast, and therefore a sale, and the entire transaction with the railways has to be taxed at the rate of 12%, my lords. As if it is a sale of ballast from the petitioner to the railways, my lord. But they forget about the agreement which was entered into by the railways, which includes, my lord, that from the crusher unit, ballasts have to be crushed into appropriate sizes. It have been transported to the railway sites, stacked as per the directions of the railways, then carried to the relevant areas, my lord, where the ballasts have to be laid, my lords. And your lordship would appreciate that the 147 income tax, my lord, begins with reasons to believe, my lord.
No, but this SLP that's been referred to?
No, that SLP, my lord, unfortunately,
Vijay Durga.
My lord, that my lord, SLP, I'm sorry, I couldn't get that, my lord. They say, my lord, supply of ballast to or stones, my lord, amounts to sale.
Correct.
But they do not consider a situation where an agreement of the railways say that I have to give or transport these materials to the railway site. And therefore, the transportation costs have to be excluded, my lords. The rest of it would be supply. It can't be 100% supply, my lords, or 100% sale, my lords.
No. So are you aggrieved only because the transportation cost has not been excluded? Are you aggrieved by treating the entire thing as sale?
My lord, my humble contention, my lord, is if your lordship, I have all, that's where annexed, my lord, the certificate given by the railways, my lord. That's annexure 4 at page 30. For both the years, lordship got it? Page 30, annexure 4.
Right.
This is a certificate, my lord, which was issued to me by the engineer of the railways, Sambalpur division, my lords. This is to certify, that's the name of the proprietor, my lords, residing at so-and-so colony, Sambalpur, has executed contract works with Southeastern Railway, Sambalpur, via agreement number so-and-so for the work, supply and stacking 50 mm size stone ballast between CH 0 to 15,800.
No, so there are two questions that arise.
My lords.
One is 12 plus 14, you are saying it should be only 12.
It should be only 12.
But even on 12, you're saying it should be only 4% and not 12%. So there are two questions here.
No, the cost, my lord, what I was trying to humbly submit before your lordship, my lord, is this 4% is for the works contract part.
No, if it is a works contract, then it has to be 12 plus 14 because the
works contract, the relevant point of time was 4%.
No, then it will be 4% on 12 plus 14.
12 plus 14. But while computing,
so you're willing to pay 4% on 1497.
4%, 1497 is my cost of transportation. That has to go out, my lords, of the TTO, my lords, as per section 5
No. If the works itself involves you having to transport it up to a point, to the supply and stacking.
Supply and stacking, my lords. My humble contention, my lord, is if the bifurcation, if I'm paid separately for transportation and the cost of the ballast, my lord, while determining my taxable turnover, this transportation has to be excluded in view of section 52A83 of the Sales Tax Act, my lords, which says that the outward freight has to be excluded, my lords. And that is precisely what your lordships have also taken into consideration. May I just pass on that judgment of your lordship, my lords? In a similar situation, may I just pass on that judgment?
No, if the contract envisaged you're having to deliver it at that point where it is laid. So the entire thing is your works, isn't it?
No, entire thing is my work, my lords. What I was trying to contend before your lordship is that entire process, my lords, from the crusher to the railway site, my lord, involves a transportation charge, my lords.
So 5.1?
5.2, 5A. 5.2A3, my lords. Section 5.2A, then your lordship may come to clause 3.
Cost of outward
the cost
freight.
of outward freight or the delivery or the cost of installation.
Yeah, when such cost is separately charged.
Separately charged. My humble contention, Lord, if the railway authorities have themselves, because the first appellate authority has examined my agreement. The railway, in addition to that, Lord, the railway authorities themselves certify that this is the cost of the ballast, this is the cost which we have paid towards transportation charges, Lord. Then grouping all this together and
so
living.
Then the cost of ballast is actually what they're paying. Railways is paying for the ballast.
For the ballast.
So why is it not a sale then?
Well, in that case, it will be confined to 12% of the cost of ballast.
That's it.
At the highest, my lord.
Correct.
But it can't be on the total amount, my lord. Inclusive of my transportation charges.
The second part seems to be more reasonable, that you can't ask 12% of the entire thing.
But my lord, here my lord would see that Annexure 4 at page 30. That's a document that has been obtained by the dealer post the assessment and all.
So
in fact, the agreement did not contain such bifurcation, my lord. And that is what the authorities, the fora below have recorded, that the agreement do not show such bifurcation. The agreement is he has to deliver it at the railway site. And the clause, my lord, says only outward freight. So if he is to deliver at the railway site, then it's an inward freight. That deduction he cannot take. It is only outward freight which is to be deductible as per section 5.
No. In fact, the word outward freight is
the cost of outward freight.
Yeah.
Suppose he is
to read on.
My lord.
Read the whole thing.
Outward freight or of delivery or the cost of installation for the purpose of sale or supply of goods by the dealer when such cost is separately charged.
Right.
My first submission is it is not, as per the contract, it is not separately charged. Now post assessment he has obtained that document which my learned senior is showing. That's a document post assessment, my lord. The agreement does not contain such bifurcation.
But this
that's the my lord finding of fact.
Where is the agreement?
But this
agreement has not been annexed.
Agreement, my lord, your lordship would see, my lord, that it has been referred to by the first appellate authority at page 18, my lord. Page 18, first paragraph, my lords, of page 18, my lord, unnumbered, carefully, my lords.
The bills were raised with railways.
Sorry,
just
carefully went through the impugned order of assessment. Your lordship got it?
No. Third line from the top. The bills were. Third line from the top.
My lords, the bills were raised by the railway authorities where transportation cost and other stacking charges were not separated, but inclusive of all the work done as a composite one, which includes supply of ballast and the stacking charges, loading and unloading of charges, as well as spreading the same.
So this is the problem, sir.
No.
The bills don't show them as separate. The bills don't show them separate.
Your lordship, this is my submission, lords. But your lordship would turn to the finding, lord. Carefully went through the impugned order.
Right.
Carefully went through the impugned order of assessment and the averments made by the learned counsel for the appellant. The main contention in this case is whether the work awarded to the appellant by the railway authorities towards supply and stacking of stone ballast is a works contract or a sale or supply. A perusal of the agreement entered into by the appellant with the Southeastern Railway Sambalpur shows that the appellant has been awarded the work of supplying and stacking of 50 mm size stone ballast between CH number so-and-so to CH number so-and-so of the Sambalpur Maneshwar section in connection with the construction of Sambalpur Talcher rail link project. The scope of the work in Schedule A attached to the agreement covers supplying and delivery of 50 mm size stone ballast of approved size, quality from the outside the railway land and stacking the same either allow the top of bank or top of cutting or on the formation itself as directed by the engineer in charge, and it requires all incidental charges, etc., complete as required. It presupposes that the appellant had to supply the stone ballast, stack the same on the railway site as per the direction of the railway authorities. The work order does not specify the work of supply and stacking of the and transportation of the same separately.
So he has accepted your plea that you will pay 4% on the entire value.
He has accepted the plea insofar as 4% on the entire work is concerned. He has accepted it.
Oh, he has not separated out.
He has not separated it. No, I was arguing against myself that at the highest, if your lordship would say that it is the same.
That's how you've succeeded before the first appellate authority. He's not accepted splitting.
No.
He's treated as a composite
It's a composite works contract and 4% on that. And that's how he has.
I think that has been your case. You should be consistent with that case. If you insist on taxing as a sale, then you're in trouble. Then you're yourself splitting. If you're saying pay 12% for the ballast because it is a sale.
Well, we're treating the entire.
That is too much.
Because towards the last of that page,
then there is no, you're not separating out the element of sale for supply of the ballast from the transportation of the ballast.
Because the transportation can only be deducted if it is an outward freight.
No, how he's not selling the freight, right? If you're going to treat it as sale, then you can't treat the entire thing as sale, please.
The statute says if he is to sell from the mine speed,
then you can't.
From the mine speed, if the sale is made,
if you're delivering it at the point of where the ballast is created, that is the crushing is happening.
Yes, that would have been the different thing. Then that's what my point is, he is delivering it at the railway site.
So you can't treat, I'm saying this entire thing as sale, please.
But
you're treating the entire thing as sale.
But the statute says only the outward freight is to be deducted, not the inward freight.
My learned friend is missing out on or of delivery.
Yeah.
Outward freight or of delivery.
Correct.
So even if I'm out of outward freight, the delivery portion also cannot be ignored.
Correct.
5.2AA3.
Absolutely. Whatever it takes to deliver, that has to be taken out. Anyway, this can't be sale then. It's one composite works contract. I think that's the right way to read it. This is a challenge in the present petition. Is to the order dated.
This order will cover both 25 and 26.
All right.
For different 2 years, 92-93 and 93-94.
Right. 25th June 2007, passed by the full bench of the Orissa Sales Tax Tribunal, Cuttack Bracket Tribunal, in essay numbers 553-554 of 2000-01 for the years 1992-93 and 1993-94 respectively. By the impugned order, the tribunal set aside the two separate orders dated 16th May 2000 passed by the Assistant Commissioner of Sales Tax, bracket ACST, bracket Sambalpur Range Sambalpur, allowing the assessees appeal case numbers AA 150 and 151, bracket SA.1 of 1988-99 for the said 2 years. It will be noted here that the ACST, that is the first appellate authority, had reversed the assessment order dated 13/5/1998, and there are two assessment orders, right? This is common to 25 and 26. Yeah. So the two separate assessment orders dated 13th May 1998 passed by the sales tax officer. Sambalpur 1 circle, Sambalpur, bracket STO. Under section 12, bracket 8 of the Orissa Sales Tax Act 1947, bracket OST Act. Paragraph. In effect, the STO reopened the earlier assessments made under section 12, bracket 4 of the OST Act in respect of each of the years by acting on the report of the Inspector of Sales Tax, bracket Circle Inspector of Sales Tax, bracket Circle IST, as well as the report of the AG audit, which had objected to the fact that the supply of ballast to the railways by the petitioner as a by the petitioner pursuant to a works contract had been taxed at 4%, whereas the supply sale, whereas it should have been considered to be a sale of ballast and taxed at 12%. Paragraph. While admitting this revision petition,
on 5/2/2008.
Yeah, on 4/2/2008.
5/2.
One is 4/2, the other is 5/2.
5/2, my lords.
While admitting each of these revision petitions, this court framed the following questions, which are common to both the petitions. Take from page 10 and 11, A to G. By separate interim orders, this court has also granted a conditional stay upon the petition depositing rupees 1,50,000. Sorry, rupees 40,000 in STREV 157 of 2000 and rupees 1,50,000 in STREV 156 of 2007. Paragraph. As regards the reopening of the assessment under section 12, bracket 8 of the OST Act, it was submitted by Mr. Counsel for the petitioner that the reopening was based on a mere change of opinion by the STO, which was not justified in law. Paragraph, the court finds that the reopening of the assessment was based on the reports of the Circle IST and the AG audit, both of whom objected to the taxing of the both of which objected to taxing the works contract at the rate of 4%, whereas since the contract involved supply of ballast, it should have been treated as a sale of ballast. So without entering into the question whether such opinion formed by the Circle IST and the AG audit was right, the court finds that the reopening by the STO was not on a mere change of opinion, but on the basis of materials made available to the STO. Full stop. Further, these materials were the SSC was confronted with these materials, and it's only thereafter that the impunity assessment order was framed. Consequently, as far as the first question is concerned, the court is of the view that the reopening of the assessment cannot be said to be without jurisdiction. Question number 1 is therefore answered in favor of the department and against the SSC. Paragraph. As regards the certificate issued by the railways, showing separately the cost of ballast and the cost of transportation, Shikara refers to section 5 bracket 2 bracket 4 of the OST Act, sorry, 3 of the OST Act, which states that, open quotation, the cost of outward freight or of delivery or the cost of installation for the purposes of sale or supply of goods by the dealer, when such cost is separately charged, unquote, is required to be excluded from the taxable turnover. He accordingly submits that in terms of the certificate of the railways for the year 92-93, rupees 1497,990, and for 93-94, rupees 400,544, being the respective costs of transportation, loading and unloading, and stacking, had to be excluded from the taxable turnover. Paragraph. The court finds that even in the order of the ACST, which was in favor of the SSC, it was noted that the bills raised by the SSC was for the composite sum of supply and stacking of ballast, and that the transportation cost was not separately shown. Full stop. In other words, there was one composite charge for supply and stacking, which included transportation costs. In fact, in the operative portion of the order of the first appellate authority, all that was said was that the contract had to be treated as one composite works contract without separating out the elements of supply of ballast and its transportation and stacking. Full stop. It is on this basis it was found that the STO was not justified in taxing the said contract as a supply, thereby reopening the assessment under section 12 bracket 8 of the OST Act. Paragraph. Learned counsel for the department, on the other hand, insisted that section 5 bracket 2 bracket capital A bracket 3 of the OST Act would get attracted only if the cost of outward freight or of delivery, open quotation, is separately charged, unquote. In the present case, and admittedly, it was not separately charged. The SSC could not take advantage of the said provision to exclude the transportation costs from the taxable turnover. Paragraph. The above submissions have been considered to understand whether the contract envisages supply of ballast and the transportation thereof as separate components. The very wording of the contract in question has to be understood. Full stop. It is seen from the order of the first appellate authority that the contract, the agreement in question was examined, and it was found that it was one composite works contract which did not separately indicate the costs for supply of ballast and the transportation or delivery charges. Full stop. This order by the first appellate authority, which was in favor of the SSC, insofar as it maintained that the entire works contract to be charged only at 4%, was not obviously challenged by the SSC. It was challenged only by the department before the tribunal. Full stop. In other words, the finding of the first appellate authority that the works contract was one composite contract with the costs of supply of ballast and transportation not being shown separately, and therefore not amenable to separate treatment, has attained finality. Even otherwise, the court finds that if it was one payment which included the elements of supply of ballast, if the payment for the if the payment was a composite one which included the elements of supply of ballast and the cost of transportation up to the site of stacking, then clearly the SSC could not have insisted on excluding the cost of transportation. Stop. Consequently, as far as questions B and C are concerned, the questions are answered in favor of the department and against the SSC. And it is held that the tribunal was right in including the transport charges as part of the taxable turnover. Paragraph. Turning now to the questions D and E, the court finds that as a logical corollary of treating the contract as one composite contract, where the elements of supply of ballast and its transportation are not separately treated, the department could not have proceeded to reopen the assessment on the basis that the entire contract must be treated as only of supply of ballast and nothing else. Full stop. Here section 5 bracket 2 capital A bracket 3 of the OST Act clearly envisages the element of delivery to be treated differently, and if so treated, then it is not possible to agree that the entire contract would amount to merely a supply of ballast. Paragraph. In other words, the entire consideration for the performance of the contract cannot be treated as a mere sale by the dealer of ballast, thus making the entire sum for performance of the contract to be a sale consideration, which would attract tax at 12%. Full stop. Therefore, on merits, the court finds that there was no justification in reopening of the assessment. Full stop. In other words, the entire consideration received by the SSC for the performance of the composite works contract would be amenable to tax at 4%. In effect, the court is therefore affirming the order of the ACST while setting aside the orders of the assessing the STO and the tribunal. Questions D and E are answered accordingly. The revisions are disposed of in the above terms. The amount of tax already paid by the SSC will be adjusted while raising the final demand.
Or refunded.
Sorry?
Or refunded, sir.
Or if excess is found to have been collected, to be refunded in accordance with the applicable rules. The revisions are disposed of in the above.
25 and 26. Both.
That's right, both these. So put both the cost titles together. So Yeah, 2 o'clock. Yeah.
Passed over item number 7.
And next item was mine. I have been called in another court.
All right.
No, I
Yes.
was afraid that Lordship may give me another compliment for arguing without a brief. Actually, it's a case of 8586. So this morning only I took from some scribblings from your Lordship brief. I'm found that the question is very interesting. Therefore,
You're appearing with the state or?
No, sir.
27, my lord.
27.
27.
27. Lordship may see the question of law is dated 12/4/2000. It is regarding that back-to-back contract 5(3) of the CST Act, which was brought into the statute section 5 subsection 3 after that Sirajuddin case. Lordship remembers in 75 this was brought that if I back-to-back contract is made for export, then that should be allowed. Here what happened, the petitioner has sold this groundnuts to one Tana exporting company. He in turn gives to another exporting company and it's exported out. That finding of the tribunal, but tribunal partly allowed my appeal. Lordship will see now page 22. I'll take directly to a Lordship, page 22, para 3.1 of the tribunal's order. True, there was an export contract by a foreign buyer with the Indian export house for purchase of groundnuts. Tana Exports Private Limited entered into agreement with the appellant buyer. Then page 23, in the present case, the purchase made by the appellant dealer is not a purchase occasioning export. On that ground, it has been disallowed. This supply to Tana.
In fact, my lord, may I pray, since both my learned senior and me also not having the record, I will take a copy from your lordship's record.
All right. Both counsel require a copy of the paper book from the court. They may obtain a soft copy thereof on a pen drive. From the court master.
Yes.
This next Monday.
May I make another payment? I've got another item 41. Now I've been called in another court. 20.
Right. Item 41 also you call on Monday. 28th. All right. Now we'll take up that.
Special weekly list item 7.
May I please your lordship?
Yes.
In batch of petitions, I am appearing except sub-item number 1, 2, and 3, my lord.
So 1, 2, and 3, you say none appears, dismissal, non-prosecution.
So far on other items, my lord, in this writ petition, I have challenged the notification.
Except 1, 2, and 7, you said, right?
1, 2, and 3, my lord.
1, 2, and
sub-item 1, 2, and 3.
All right. So your first item is 3543 of 95.
First item is 9919 of 2001.
No, but you're not appearing, you said.
No, sub-item 1, second, third, and fourth, my lord. Sub-item 1, 2, 3.
Oh. You're appearing in 1, 2, and 3.
Except these 3 items, I'm not appearing. I'm appearing in all other cases.
So if you accept these 3 items, then what you're left, your starting point will be 3543.
My lord, I'm not appearing in OJC 1969 of 94. OJC 3542 of 95. And OJC 3543 of 95.
So you're not appearing in 2, 3, and 4, sir.
2, 3, and 4.
My lord. So sub items 2, that is 1969 of 94, 3542 of 95, 3543 of 95, none appears, dismissal, no prosecution. Now come to 9919.
My lord.
this writ petition, I have challenged the notification published by the SRO number 615 of 91, rescinding the earlier notification that dated 8/12/1966. My lord, what has happened? Before going into the merit of the case, I prepared a rate chart, my lord. The matter relates to actually 1966 notification. So in the year 1957, the Central Sales Tax Act enacted, and section 14 and 15 as originally enacted, I have quoted at page 5 of my writ petition. Then, my lord, section 15 of the CST Act amended by amending 2% to 3%. The rate of tax has been amended from 2% to 3%. Then the state government, being empowered under section 8(5) of the CST Act, issued the notification bearing number 43637 CTA-200/66. My lord, that is important. Therefore, your lordship kindly have a glance to that notification at page 8, para 8 of my brief.
Yes. Yes.
My lord. Page 8, para 8.
Yes.
That in the meantime, the state of Orissa, by virtue of their power under section 8(5) of the CST Act, has issued the notification bearing number 43637 such and such on 8 December 1966, which reads as under. In exercise of the powers conferred by subsection 5 of section 8 of the Central Sales Tax Act 1956, the state government, having been satisfied that it is necessary to do so in public interest, hereby direct that in respect of all declared goods sold in the course of interstate trade or commerce, no tax under the said act shall be payable by the dealer having his place of business in the state of Orissa, state in respect of the sale by him such goods where tax has been levied and collected in respect of the sale or purchase of such declared goods under section 5(1) of the Orissa Sales Tax Act. So, my lord, if I'm a dealer inside the state, I am dealing goods as specified under section 14 of the CST Act and paid tax under the state act, then no tax is payable under the CST Act. This is the notification. My lord, after that, this notification, along with validation of clause 15 has been challenged before this honorable court in the case of Orissa Heights and Trading Company Limited. Your lordship, kindly turn to page 6, running page 6.
Yes.
Para 5, million. The net effect of notifications means this 1966 notification which I have referred. However, is that in respect of dealers' transaction in the course of interstate trade or commerce, there would be no tax under the Central Act provided the two contingency indicated in the notification are satisfied. The fact which requires proof is that tax has already been imposed and collected under section 5(1) of the State Act, and the same has not been refunded to him, or claim in that belief is not to be made under the provision of section 15B of the Central Act. This fact has to be established by the assessee. The mandate in section 15B of the Central Act is that the tax under the State Act is to be refunded once the same goods are sold in the course of interstate trade or commerce and are assessed to tax under the Central Act. Kedar and Co. versus State of Madras reported in 17 STC. Judged from that angle, the notification embodies a converse scheme, that is where the state tax is collected and the dealer shall not claim refund of that tax under section 15B of the Central Act. The central sales tax shall not be payable. The statutory notification in exercise of power under section 85 of the Central Act cannot be permitted to run counter to section 15B of the Central Act. That view has been taken in Rafiq Ahmad and Company versus State of Andhra Pradesh, reported in 24 STC 430, and we respectfully agree with the same. The tax to be refunded under section 15B of the Central Act is the tax levied under the State Act. The notification, in our view, is misconceived one, though it was intended to avoid the hardship of claim of refund. We hold that it is not enforceable. So the Honorable High Court has held that that notification, 1966 notification, is not enforceable. This decision has been followed subsequently by two other decisions of this Honorable.
No, so what it means is that you will have to pay Central Sales Tax Act.
My Lord. Then all these three decisions came before the full bench of this Honorable Court. Kindly turn to page 18, Milo.
Yes.
The relevant paras at the running page 21, Milo. My Lord, got it?
Yes.
After considering the decision of the Honorable Supreme Court in the state of Mysore and Yadalam Lakshmi Narasimhaiah, Shetty and Sons, the Honorable
So they
Court,
upheld the notification.
my Lord,
They upheld the notification.
they upheld the notification. Then what has happened? The state government has rescinded that notification, basing on the earlier judgment of the Honorable Court.
Okay.
Then that was challenged in another case. That is, it starts at
Jankiram Jain.
Jankiram Jain. There, the Honorable Court had decided that no, the state government is not empowered to rescind that notification. After the Jankiram case, state government again rescinded the notification, which is the impugned notification.
Oh, I see. So this also has to go, therefore. So
me?
this also has to go.
This also has to go.
All right. Yes.
And-
What do you say? Who's for the state?
Last letter, I don't have the copy of the writ petition. That is 9919 of 2001.
Then if nobody is appearing, we'll simply allow it. None of you has been authorized to appear. Then it's okay. Because again, the same thing's been happening over a period of time.
Till that, no counter have been filed, my Lord, in any cases.
All right. The challenge in the present petition is to a notification dated 14th August 1991, issued by the Finance Department, Government of Orissa, rescinding an earlier notification dated 8th December 1966 under section 8 bracket 5 bracket small b of the Central Sales Tax Act 1956 paragraph. While directing notice to issue in the present petition on 3rd September 2001, this court directed that no coercive measures will be taken against the petitioner in relation to the demand made by the assessment of by the sales tax officer, Bruce's assessment order dated 23rd March 2001 for the period 1997-98. The background to the present petition is that the petitioner is a partnership firm engaged in the business of purchasing and selling coconuts to persons mostly outside the state of Orissa. Full stop. The petitioner was paying purchase tax under Section 3 Capital B of the Orissa Sales Tax Act 1947 (OST Act) on the purchase value of the coconuts, and was not being assessed under the Central Sales Tax Act 1956 (CST Act) by virtue of a notification dated 8/12/1966. Which had been issued by the state government under Section 8(5) of the CST Act, directing that in respect of all declared goods sold in the course of interstate trade or commerce, no tax under the CST Act shall be payable by any dealer having his place of business in the state, provided that he is able to show that tax has been levied and collected in respect of the sale or purchase of such declared goods under Section 5 (small 1) I small I of the OST Act. Paragraph. The validity of the above notification came up for consideration first in Orissa Heights Trading Company was the sales tax officer, 1975 35 STC 232 (Orissa). It was held that a statutory notification under Section 8(5) of the CST Act cannot be permitted to run counter to Section 15 (small b) of the CST Act, in terms of which the tax collected under the State Act was to be refunded once the same goods are sold in the course of interstate trade or commerce and are assessed to tax under the CST Act. Full stop. The decision of Orissa Heights was reiterated in K. Narayana Kumandan, Sons and Company vs. STO, 41 1975 CLT 1042, as well as Subudhi Krishnamurthy and Sons vs. STO, 1975 36 STC 419 (Odisha). Paragraph. When the correctness of the above decisions were questioned, a full bench of this court in Kamal Kumar Agarwal was the sales tax officer, reversed the above decisions by holding that it is perfectly open to the state government to issue a notification under Section 8(5) of the CST Act, exempting declared goods from any CST in respect of goods sold, in respect of such declared goods sold in the course of interstate sale. Paragraph. Unmindful of the full bench decision, the Orissa High Court, the Orissa government rescinded the 1966 notification on 23rd April 1991. Paragraph. Challenging the rescinding of the notification of 1966 in the above manner, another writ petition was filed at this court, which came to be allowed by a division bench. Full stop. In Janaki Ram, division bench in Janaki Ram Jain was the state of Orissa, 1991, 83 STC 169 bracket Orissa. Paragraph. Notwithstanding the decision in Janaki Ram Jain, the government of government of Orissa again rescinded the 1966 notification on 14th August 1991. And it is the said notification no, that 1991 rescinding has not been challenged.
That is under challenge.
No, I think what you challenged is 2001, right?
No, again, the state government has implemented the said notification in the year 2001. Miller.
Oh, I see.
In guise of public interest.
Okay. Applying the said rescinding of notification, the impugned assessment order has been passed against the present petitioner. And therefore, the petitioner has challenged both the notification dated 14th August 91 and the assessment order dated 23rd March 2001. Paragraph. Despite notice having been issued in the petition way back on 3rd September 2001, that is more than 20 years ago, no counter affidavit has been filed by the state government till now. Paragraph. With the full bench of this court in Kamal Kumar Agarwal versus STO, Supra, already settling the issue. It was erroneous on the part of the state government in the first instance to rescind the notification of 1966, which in turn led to a second decision in Janaki Ram Jain versus State of Orissa, 83 STC 169. Notwithstanding this, the government of Orissa seems to have again rescinded the 1966 notification on 14th August 1981. This too has to meet the same fate as the earlier attempted rescinding of the similar notification. Stop. Applying the decision of the full bench in Kamal Kumar Agarwal, Supra, and the division bench of this court in Janaki Ram Jain, Supra, this court quashes the notification dated 14th August 1991 of the Finance Department, rescinding the earlier notification of 1966 under Section 8, bracket 5. Earlier notification dated 8 December 1966 under Section 8, bracket 5 of the CST Act. So as a consequence, the impugned assessment order dated 23rd March 2001.
I submit that if the 1966 circular is revived, then that would not mean that the assessment order will go, because then he has to demonstrate that he has paid OST. Then only the CST will not be leviable. And in all the cases, the cases in which I have the brief mail, there the refund has been taken of the OST. OST that has been paid, he has taken refund.
Go back to the AO now.
So it will not automatically mean that the
so can go back to the AO now.
Yes, my lord, kindly have a glance to the notification itself, 1966.
Yes.
My learned friend is a little bit confused.
The burden of proving the taxes on the SSC.
Assessment. There is no tax under this act shall be payable by any
provided you show that you have paid tax under the OST.
Okay, my lord. Your lordship may demand.
The matters are therefore remanded to the AO in each of the cases for a fresh assessment order to be passed in light of the above decision. The matters will be placed before the concerned AO, that is STO, on 2nd May 2022 for directions. The petitions are disposed of in the above terms. Mr. Patnaik's case.
Special weekly list, pass over item 18.
May I please? This is a stay revision case, my lord, where about challenging the order of London Tax Tribunal. My lord. Here is the case that this honorable court has placed to admit the matter and already framed two questions of law. Number one, whether on the facts and in circumstances of the case, the London Tax Tribunal is justified in confirming the enhancement of ₹7 lakhs made in case of search and seizure operation conducted by the department in an exhaustive manner against the detector's operation was at ₹2,25,770 or irresistible information done by the London Tax Tribunal at 1,80,000, which ought to have restricted to the extent of detection of suppression as per the report of investigating authorities. Either at
no, there's only one question, so I don't know what you're going on reading.
This is one question. The second question is
no, there's only one question in the petition. This is STREV 80, right?
My lord. STREV 5 of 2006.
No, my lord, STREV 5 of 2006, the connected.
80, what happened?
80, my lord, has disposed.
It already also disposed small effect. Let's dispose of that is a small tax effect. Some 11,000 some are
connected matter.
It is not connected, it is another matter. It is wrongly tagged. This is a matter where this honorable court has taken two questions of law, accepted two questions of law. One is that whether in search and seizure case, whatever the amount detected, it should be restricted to that, it cannot be enhanced. Number one. Number two, whether when enhancing the turnover, they are giving rebate of tax fund, husband tax paid goods, whether the authority can do so or not. These two questions before my lord, you are has already framed. So far as the first question is concerned, my lord, in that context, here is the fact is that there was a search on dated 31/7/1999. That means the financial year after 4 months there was a search, but they have taken entire year together and enhanced the turnover to 10 lakhs. Who is the London Tribunal has restricted it 1,80,000 and the suppression and enhancement to 7 lakhs. So here the prayer of the petition is that the restriction should be to the extent of suppression has been pointed out. That is 1,80,000. In that context, I am giving one case law before my lords. I already supplied. It is state of Orissa versus Fancy Motors Associated Agencies reported in on dated 9/87, my lord, paragraph 6, page 37. It has been clearly split out. London Council for the Dealer referred to us a decision of the Kerala High Court in case of PS Ithivathubasan and State of Kerala 37 STs 184, where in view of the appellant assistant commissioner, the suppression actually detected could be considered only to cover 6 months for the reason that the inspection has been made in the middle of the year. There is a long discussion in this aspect of the matter to indicate that an inspection on one occasion in course of
the next tax effect here also is not substantial, sir.
No, here is, my lord, here tax 1,37,000 summers. Because in the first appellate authority has enhanced the tax to ₹1,37,000. That is at page 33 of the tribunal's own order, paragraph 3. In appeal, the London SCST sustained the pending of suppression and enhanced made that to the GTO by the London Assessing Officer. But the London SCST found out that the London Assessing Officer has allowed reduction whole of 50,000
urgently to send a sir.
Towards first point tax paid goods from the GTO in absence of any evidence of such purchase from registered dealer. Consequently, after issuance of notice of show cause as required under section 23(2)(a) of Post Act, the London SCST added the same to the TTO in the appropriate tax group, due to which the extra tax demand was raised 1,39,432. He has told that when 10 lakhs they have enhanced, so they have entirely to be taxed. It should come under entire taxable group, not first point group. That's why they have made further addition 1,39,432. Apart the addition 78,000 hours. Therefore, before my lords, with the two questions of law, which was rightly accepted by this honorable court while admitting the matter.
As regards the first question of law regarding not giving credit of the first towards the first point tax paid materials, in fact, page 33, para 5 of the impugned order, tribunal's order, my lord would see that he has not produced any proof of payment of tax at the first point, my lord.
Right.
So, as regards the my lord, enhancement, the suppression was found to be on the date of search. It was found 2,25,770, which was enhanced by 10 lakhs by the AO, and now it has been reduced to 7 lakhs by the tribunal. So, my lord,
That doesn't call for any interference. Actually. We've already reduced it. We already reduced the addition, sir, from 10 to 7. This is not actually any question of law at all. You say, while admitting this petition on 24 July 2006, the following questions were framed for consideration. So, one minute. What is happening, sir? I specifically asked you to send, madam, please carry on it. You can even proceed. The other stenographer. Kindly proceed. Kindly proceed, sir. The other stenographer. Is he supposed to take or someone? Admitting this revision petition on 24 July 2006, the following questions were framed for consideration. There are two questions there. As far as the first question is concerned, the court finds that the tribunal has in fact reduced the amount of addition from rupees 10 lakhs to rupees 7 lakhs in the matter of detected suppression of rupees 2,25,770. Having heard learned counsel of the parties, the court does not consider the tribunal having erred in making such reduction and is unable to agree with the SSC that the addition should have been restricted to the amount of suppression. Paragraph. As far as second question is concerned, the tribunal on facts found that SSC was unable to produce documents to show that tax had in fact been paid at the first point. In that was the matter, both questions are answered in favor of the department and against the SSC. The revision is disposed of.
My lord, I am excused to place something. My lord, so far as the decision of the state of Orissa versus Fancy Motors case, my lord, this is the own
Sir,
High
I've
Court
dictated
decision.
the matter now.
It is restricted to the extent of whatever dictation is there.
Or
Specifically list item 20.
as far as the decision in state of Orissa versus Fancy Motors Accessory Limited,
Paragraph 6.
69 volume 69, 1988, STC, page 34 is concerned, the court finds that it has turned on the facts of the said case and its distinguishment. All right.
Special weekly list item 28.
In fact, item 28, my lord, I have no record. I have checked up. My lord is also not having the record.
No, we have.
Hard copy is not there.
That's okay.
Perhaps hard copy is not there. I couldn't see, my lord. Then I will take a soft copy, my lord. Hard copy is not there.
You see what the question is, sir. No ID card, nothing has been. You say no steps were taken for service of notice on the opposite party from 12/12/2007 onwards. The petition is dismissed for non-prosecution. Yes.
Special weekly list item 29.
May please, Lordship. All these 10 writ appeals arises out of a common judgment by His Lordship, single judge, wherein one thing your Lordship is to decide whether that Succession Act came into force in 1956, your Lordship. That is 17th June 1956. Widow and daughters, they become the absolute owner in respect of the property.
All right. Placed before a bench of which Justice Patnaik is not a member on 19th April. Right.
Special weekly list item 30.
Well, item 30, my lord. Well, I was told that somebody has withdrawn it at the time of mentioning. Well, I am the counsel in this matter. I have not withdrawn that matter.
Argue.
Yes, ma'am. On the last date of hearing, my lord, the government council, they had complied with the order dated 19/4/2021 of this honorable court, and they had filed this affidavit, wherein, my lord, listen.
Yes, carry on, sir.
Yes, ma'am. Well, on the last date of hearing, they had complied with this order and filed this affidavit, wherein they had themselves admitted my case, whatever I am claiming, that this the ground in question is a playground. And my lord, that cannot be, my lord, as per my submission, that cannot be converted or cannot be alerted without following the due process of law, my lord. My lord, in meanwhile, what has happened, my lord? The petition number 1 has died just 15-20 days back. He was a bit ill. But I want to file a response to this affidavit. If my lord will permit, I maybe take some time to file the response to this.
There are so many petitioners, sir. When did you get this affidavit?
My lord, that was in January, my lord.
Then?
My lord, but he was particularly the petition 1 was ill for some time.
No, this was filed in November 21, sir.
My lord, due to this COVID and all.
No COVID and all. Just come. Let's not waste time. This has gone on and on, sir. It's a 2008 petition.
Well, only just to put something on record. Otherwise, I am ready with this matter.
Be ready. We start.
My lord.
My lord, after 9 years of delay, this writ petition has been filed.
All right.
My lord, my case is that, my lord, the petitioners are the permanent residents of Shahid Nagar, Bhubaneswar, is one of the locality in Bhubaneswar. My lord, and in the middle of that locality, there is one ground which I had filed annex. I filed the map of that particular ground is annexure 3, my lord. My lord, that ground, my lord, it was demarcated in the original my lord, land use plan, my lord. It was demarcated as the playground for the children, my lord. And my lord, what happens, my lord, during some course of time, some people, I mean, were encroached upon that. All labors.
There's still a playground there, sir.
My lord?
Come to the photograph.
Yes, my lord. It is a playground, my lord.
Then.
Well, my question is that how can they convert the playground to a, how they cannot, I mean, directly.
It's still a playground, sir. What have they converted? They've not converted anything. It's still a playground.
No, they have allotted it to Orissa State Housing Board.
Where do they say that? In their reply, where do they say that?
Yes, my lord, in the reply. It is in their reply, my lord, annexure F5, my lord, the page internal page 16. F5, my lord, the allotment of land in favor of OHCB in.
Where are you reading, sir?
The page, internal page 16, annexure F5, and that is the allotment letter.
Counter affidavit of
counter affidavit of the government, my lord.
Of opposite pattern 2.
The opposite pattern 1 and 2, my lord.
You have to say all that, sir. We can't just guess all this.
My lord, the paging actually the.
No, you have to say at least which document you're reading from.
My lord, the annexure F5 of the counter affidavit of the by the government. Internal page 16, my lord. And my lord, I'm sorry.
What is 1 and 2? 170.
Lord,
This is computer page. Come.
Hello,
Yeah,
may I read the counter affidavit, my lord? Filed by the government, my lord.
This is on opposite party number 2.
Oh, opinion to my lord. Unfortunately, the case has been reconstructed. I could not tell you the page number, so that's why the difficulty. I am reading the counter affidavit by the opposite party number 2, my lord.
Sangram Kumar Raisadar.
Yes, my lord. Sangram Kumar Raisadar. Yes, my lord. Yes, my lord.
What?
Yes, my lord. My lord, the next page, my lord.
Yes, please.
My lord, in the page, internal page 4, my lord.
Yes.
They have said on the last paragraph, 9/7/98, the site selection committee meeting was held in the chamber of the director of estates. In the said site selection meeting, the committee members recommended to allot the land in favor of the OSSB, subject to change of land use plan by the BDA. My lord, then the next page, my lord, 22/10/1998, GA department RI reported that the plot number 823 measuring so and plot number 1523 measuring so is kept for lawn in the drawing, and the next comes the plot number 1722. That is the plot in question, my lord, in my read petition. The plot number 1722 measuring acre 354, plot number 1723 measuring so and plot number 1724 measuring so is kept for playground in the drawing. Well, in their counter affidavit, they have also admitted it is a playground. Well, then comes the order of government, the next date, the next line, 31/1/1999. Order of government obtaining for allotment of acre 0.806 and acre 0.774 of land in Shahid Nagar in favor of OSSB, Orissa State Housing Board. Then 16/2/1999, GA Department Wide Allotment letter number 3199 dated 16/2/99 allotted land measurement acre 0.806 and wide allotment order 3204 dated 16/2/99 land measuring 0.690 allotted to Orissa State Housing Board for implementation of social housing scheme. Well, here, my lord, they are saying that okay, they have allotted this land. Though in the upper para, they have clearly mentioned, RI reported that the plot number so is reserved is for the playground.
You're mixing up, sir. Only 2 of the plots have been allotted.
Yes, my lord.
Your plot 1722, they have not mentioned here at all.
Yes, 172324.
Which is your plot?
Yes, my plot is 1722, 23, and 24. Man, it is in the first para, my lord, in the said page.
But those 3 plots are not mentioned here. In the allotment, those
ma'am.
3 plots are not mentioned.
It is there, and they have also annexed it in the.
Here in this narration, it is not there.
It is there, my lord.
Where?
Acre 690, my lord. Acre 690 equivalent to this combined area of these 3 plots, my lord.
Where do you get that?
My lord, in the same page, the first para, it is written the plot number 1722 measuring 354, 1723 measuring 069, and plot number 1724.
But it's for implementation of social housing scheme.
Yes, my lord.
What is wrong with all this? We are not able to understand. What is the public interest here?
That is the plot, my lord.
What is the public interest here, you tell us?
No, my lord. My lord, one playground, my lord. Reserved for play, children.
It is still vacant, sir. It's still
There is a playground and there is some person is allotted to us.
No, not some person, my lord.
This doesn't have to engage this court for so many years, sir.
Yes, my lord, there must be some reason, my lord.
It's all right.
During the last 14 years, my lord.
It's all right. It's all right.
No, my
this
lord.
is not
But
such a
I'm not-
serious issue. Please.
Yes, my lord, I am not done with my lord. My lord, it is pending for 14 years. There must be some reason, my lord. My lord, it is, my lord, I am coming to my region, my lord. My lord, my submission is when a ground is or any plot of land is reserved, my lord, for playground, it is comes under Rakhit Khatyan. And there is a process of de-reserving their said land, and then only it can be converted to some other purpose.
That we will do.
Well, my lord, that I have mentioned in my region, my lord. My lord, Odisha government, OGLS, my lord, Odisha government land. My lord, the section 3, my lord, OGLS, my lord, it clearly says which plot can be reserved for what purpose. This is a communal land. Well, just like a gocha, this is a playground, is a communal land, and it is a reserved land. And what they have done is, without following the due process of law, they have simply allotted to Odisha State Housing Board. That is my case, my lord.
All right. Anything else, sir? Anything else?
My lord, I have mentioned that in my region, my lord. Kindly go through that.
All right. Same thing. What you just argued, you mentioned in the rejoinder.
Yes,
right?
ma'am. Yes, ma'am.
The petitioners are aggrieved that 3 plots, numbers 1722, measuring AC 0.354, 1723, measuring 0.069, 1724, measuring 0.351 decimal. Aggregated to AC 0.690, which have been earmarked in Shahid Nagar, is it?
Yes, ma'am. Shahid Nagar.
Bhubaneswar, which is earmarked for a playground in the master plan, has been allotted to the Orissa State Housing Board for implementation of single court social housing scheme. On (19/4/2021), this court had passed an order directing the government to file an affidavit not later than 17 May 2021, including photographs to show the current status of the land in question. Paragraph. Pursuant thereto, an affidavit has been filed by opposite parties 1 and 2. Stating that in the comprehensive development plan prepared for the year 2010, the said 3 plots have been assigned for single courts playground. Full stop.
Sketch map is annexed.
Right now, the said land is lying vacant with a compound wall. Photographs showing the vacant land has been produced. Full stop. Since the land is even as of today vacant and has not been used for any social housing scheme, there appears to be no basis for the apprehension expressed by the petitioners. Full stop. Needless to state, if the use of the land is going to be converted from playground to any other purpose, the applicable procedures will be followed by the authorities. No further directions are called for. The petitions disposed of.
Special weekly list item 31.
None appears dismissed on opposition.
Special weekly list item 32.
That's item 31. My lord, here this matter, here the CBI inquiry was, this honorable court as director of CBI inquiry, my lords. I think they have filed the report, my lords, and that they did not found that missing lady, they could not find it, and they filed the final form.
Who's for the other side?
Case number WPCL 470.
Who's for the other side? Show me the paper books.
This honorable court as director for CBI inquiry, a lady was missing from a trail.
Which order, sir? Which is the order ordering CBI inquiry?
Yes, order is brief is my.
Which is the order?
Let's say my brief is missing, my lords. I
Very
could not
good,
get.
very good. We'll read it. Don't worry.
Here, my lords, that is.
We will read it, sir. Not to worry.
Lord, that CBI report, they have filed the final form.
We will read it, sir. We will read it. All right.
Okay.
But the final report of the CBI is at track B, my lord.
Closure report. Yeah. You see, the Central Bureau of Investigation has, under cover of letter dated 21st March 2010, submitted the final closure report. In that view, the matter, no further directions are called for. It will be open to counsel the petitioner to obtain a copy of the said report, to inspect a copy of the said report in the office of the Registrar Judicial. The petition is disposed of.
Special weekly list item 32.
May it please, my lords. Lordships, I am appearing on behalf of Mr. Jagabandhu Sahu, my lords. Lordships, may kindly allow one passover, my lords, for the day.
All right, all right.
Special weekly list item 33.
My lords, same, my lords, we are appearing
All right.
on one passover, my lords. Deeply
Special
obliged, my
weekly
lords.
list item 34.
None appears dismissed on opposition.
Special weekly list item 35.
Okay. None appears dismissed on opposition.
Special weekly list item 36.
None appears dismissed on opposition.
Special weekly list item 37.
36, I am appearing for the OP number 2 Jagannath Temple, that may be recorded. 36, opposite party, Jagannath Temple.
37, none appears dismissed on opposition.
Special weekly list item 38.
Item 38, my lords. I am appearing through VC, my lord. I am appearing for the petitioners. Here, my lord, the petitioners repeat in this petition, which we pray for a direction. We are salaried amines under the subordinate judiciary of your lordships.
We'll take it up on some other day, sir. This will take time.
Yes, Lord. But I'll be absent after May 8th. Your lordship kindly fix any date before that.
All right. List on 1st August.
1st of August, no?
Yes.
Special weekly list item 39.
None appears dismissed. No.
Special weekly list item 40.
I am appearing in item 40 in VC, my lord. In this case, the GRF, my sole point is the GRF has exceeded its jurisdiction, directing grant of compensation.
Not served, sir. Unserved notice on opposite party number 2.
Opposite party number 2, whereabouts is also not known, my lord. I have given the requisites, but the report has come.
No point, sir. You say
Question of law
service,
may be kept open.
yeah, service has not been able to be effected on opposite party number 2 in all these years. Leaving the question of law open, the petition is disposed of.
Obliged. Special weekly list item 43.
None appears dismissed, no prosecution.
Special weekly list item 44.
May I please, your lordship. Here, my lord, petitioner is aggrieved by the action of the opposite party number 2, wherein my lord, his name has been reflected in the civil list. That means he is a willful defaulter, but he has not incurred any loan from any bank. But in spite of the civil records, his name has not been deleted in the civil list.
All right. Notice was issued or not in this petition?
Not yet been released.
No point, sir. All these 9 years, 10 years, you've done nothing.
Because he is a renowned industrialist, my lords. The 3,000 crores.
It has not hurt you at all. No stay was also granted. What is the point at this point in time doing anything to the list? You say with sheer passage of time, the petition has been rendered infructuous.
Yeah, your lordship may direct I will file an application again. That may be considered.
What?
I'll file an application for deletion of my name.
You just leave it be, sir. Last 10 years, nothing has happened. You have not got any stay.
Well, till today, my lord,
you're going to revive some memory of something which is unnecessary. Sheer passage of time, all this has become infructuous. You see, there has been no stay granted by this court. Even notice has not been issued in the last 10 years. Clearly, there's no urgency, and the petition itself has been rendered infructuous. The petition is disposed of.
Special weekly list item 45.
Pardon, my lord, item number 37, my lord.
You'll have to wait, madam. Yes. 45,
no
none appears, dismissed and non-prosecution.
No instruction, my lord.
No instructions. All right.
Special weekly list item 46.
None appears, dismissed and non-prosecution.
Special weekly list item 47.
None appears, dismissed and non-prosecution.
Special weekly list item 48.
None appears, dismissed and non-prosecution. All that MC, put the MC numbers. Right from 46, put all the MC numbers.
Special weekly list item 49.
MC number, non-prosecution.
Special weekly list item 50.
My lord, item number 50. Your lordship may kindly allow me to conduct this case. My lord,
No problem, madam.
my lord, here the matter has been remanded to your lordship by the Honorable Supreme Court to decide.
Whom are you appearing for?
My lord, the challenge is about.
Whom are you appearing for?
I am for the petitioner. Petitioner.
You have filed your wakalatnama.
No, I have not filed my.
Without that, how can we hear you, madam?
Then the lordship may keep it to.
Ms. Jena states that she'll be filing wakalatnama for the petitioners. When will you file it?
My lord, by tomorrow I will file.
By tomorrow. List on 21st April.
Oh, bless.
21st.
Pardon to mention, my lord, item number 37, my lord, special weekly.
Yes.
My lord, I am for the petitioner, my lord.
Yes.
We have challenged the order passed by the learned GRF, my lord.
Yes.
So far as the status is concerned, my lord, the industry is now not functioning since long.
You leave the question open. It appears that the industry in question is not functioning. Leaving the question of law open, the petition is disposed of. Yes.
Special weekly list pass over item 32.
We'll have it next week, sir. 32, 33, this
May-
one 28.
Yes, my lords. Obliged, my lords.
All right.
Weekly list fresh admission item 1.
None appears, dismissed and non-prosecution.
Weekly list fresh admission item 2.
And pray for 3 weeks time.
For what, sir? For what? So please proceed with the matter. Last time also you appeared at your instance, it was recalled.
But item 2.
What is the matter about?
But this is, I have challenged the wires of Stamp Act. In WPC number 18303 of 2014, which is being heard with writ appeal number 446 of 2013 and WPC number 8011 of 2014. So all these matters are involved with the Stamp Act.
If this no notice has gone, virus of Stamp Act can be examined in some other matter. Even notice has not gone in the last 8 years, sir. No notice has even been issued in your petition so far.
But
It is never listed. It is never listed, I think.
I know.
Once it is listed before an honorable single judge, then.
Never listed, no notice, nothing. If there are other petitions, we'll examine it there, sir. Which are the other petitions pending?
Let it be called.
Nothing in this, sir. Why should we have multiple petitions on the same issue?
There is another writ appeal 446 of 13.
In that writ appeal, I have appeared for the respondent.
Writ appeal 446 of 2013, the order of the honorable single judge has been challenged. Wherein
we'll examine all that, sir.
The provisions of Stamp Act is being challenged in WPC number 18303 of 2014 and WPC number 8011 of 2014.
Oh, another petition is there.
Here, what has happened? The difference between a instrument and conveyance under the Stamp Act. These arose out of a.
What is the cause of action?
The cause of action is order has been passed by the Lord Civil Judge, Senior Division Cuttack, wherein it has been held that the agreement for sale, which has been marked as exhibit in a suit, the instrument is a. The Lord Civil Judge held that it is an instrument, but during the course of hearing, after the document has been marked as Exhibit 1, this has been challenged in WPC number 14123 of 2012, wherein the Honorable Single Judge held that it is conveyance, hence it is liable for stamp duty. But that was the issue in the writ appeal number 446 of 2013.
We'll examine it in that, sir.
Yes, in that appeal also this can be examined.
But for that reason, I beg to pray for 2 weeks' time.
Not necessary, sir. The issue regarding validity.
I'll argue the matter. I have already filed a note of submission.
Where is that?
That is there, my lord. On 21/2014, a note of submission has been filed, and I'll place that because that will take little time. For that reason, I wanted. I have not prepared. I have filed the decisions annexed with the note of submission.
Sir, even notice has not been issued in this petition, sir. 8 years, not even notice has been issued. And you go on asking for time. No question, sir.
Let the notice be issued.
I'm sorry. Why should we issue notice after 8 years? Why should we issue notice after 8 years? You have to convince us. Why should we issue notice?
No. In writ appeal is being heard along with writ petition number 18303 of 2014.
So what is now listed today, what has been called out is 18303.
There is no writ appeal listed today. Writ appeal is there, it will be heard, and in that case also the honorable court can decide the validity of this statute, because on the basis of this the honorable single judge has passed the order which is impugned in the appeal.
Right. This is a
But yes,
question of
all these three matters, 18303 of 2014, writ appeal number 446 of 2013, and WPC number 80 of
the
11
very
of
question involved in
2014.
this petition.
All these can be heard
is stated to
together.
be involved in writ petition civil 8011 of 2014 and writ appeal 446 of 2013. The last mentioned two matters are not before this court. There is no need, therefore, to multiply petitions in the same question. Petition is disposed of. Yes, call out the next matter.
Weekly list item 3.
Sorry. Need not be multiplied. You see, in writ appeal 446 of 2013, counsel for the appellant is stated to be in difficulty today. List on. List along with 8011 of 2014 on 4th July. It's there, sir. It's in the next page. Yes.
Weekly list item 3.
Am I permitted to withdraw your lordship?
Counsel the petitioner seeks leave to withdraw this petition. Yes, please.
Weekly list item 4.
Item 4 and 5 may infructuous.
Infructuous disposed of as such.
Weekly list item 6.
May I please your lordship? My lord, this is with regard to installation of my lord cabins on the road. Looking at paragraph 4.6 at page 6, your lordship on the last occasion was pleased to direct me to soft copy on my learned senior appearing for me, CDA, Mr. Dayanand Mahapatra. I have soft copy. Only, my lord, this 4.6, whether they have completed this process or not is to be seen, my lord. So on the basis of the paragraph 4.6, my lord, at page 6.
Well, sir, in fact, well, this construction of that particular cabins and all these things are made by municipal corporation itself. Vending zone that has been developed by municipal corporation itself.
You conducted the spot verification. That's what he says. Para 4.6.
4.6, yes, my lord.
He says you conducted the spot verification.
We conducted that report. So we wanted, give me time, I will file a counter. But fact remains, this vending zone on inquiry, it is found that the vending zone is made by the municipal corporation itself,
not CDA.
Corporation is also a party as opposite party.
Corporation.
Yes, who's for the corporation?
Opposite party number 3.
Who's appearing, Mr. Mishra, to the corporation?
My lord, in fact,
corporation a panel of law, Mr. Pradeep Mahanti, my lord, usually appears, senior advocate. Mr.
This is Devashish Naik who appears.
Mr. Shrikant Naik also appears. I will inform my lord, I will inform you.
I'll have a copy.
Counsel for the CDA now states that the CDA is not involved in the task of removal of cabins. He states that it is the Cuttack Municipal Corporation, bracket CMC, which can answer the issue raised. Mr. Mishra, Glen Counsel Petitioner states that he will serve an advance and a copy of the present petition on. Now he will serve a copy of the present petition on Mr. Devashish Naik against the CMC. Left on 11th July.
Obliged.
Weekly list item 7.
May I please, your lordship? This is the PIL filed by the petitioners. My lord, in order to prevent the traffic jam at Rajpath area, Bhubaneswar, at unit number 1, the state government GA department demolished 42 quarters and handed over the land to the Bhubaneswar Municipal Corporation for construction of a market building. Your Lordship may kindly have a glance to page 20, Annexure 1. In an area of 3 acre 822 decimal, government has alienated in favor of the Bhubaneswar Municipal Corporation, and the Annexure 2 is the master plan approved by the BMC from 2014, but no construction. Every day there is casualty. The whole intention to demolish the government quarter in order to prevent the traffic jam in the capital. It is on the central.
No, who are the encroachers?
The petitioners are local residents, and some of them are the.
Who are the encroachers, sir? You are complaining of encroachment, right?
Some people, because the
who are the some people? Who are the some people?
My lord, in fact, the land has been handed over to the Bhubaneswar municipality.
Sir, kindly listen. If you want some encroachment to be removed, you should name the encroachers.
Oblige your lordship, because the land is lying vacant, some of the street vendors are encroaching upon that.
Find out their names, put them in the representation, then file a petition. You say the representation made by the petitioners does not name, with the opposite party authorities, does not name the alleged encroachers. That way the matter, the petitioners are permitted to file a fresh representation to the authorities by naming the alleged encroachers, and after following up such representation to seek appropriate remedies in accordance with law. Petition is disposed of in the above terms.
Weekly list item 8.
The opposite part number 4 to 9 are forcibly encroaching the government land recorded in the name of government as per Annexure 1.
This representation, has it been served on the collector?
Served by some.
Where do you see that? Where is the stamp of receipt in the collector's office?
We have hand to hand.
Doesn't work like that, sir. There is no proof of submission of the representation by the petitioners to the collector.
May I pray, my lord? Let them take instruction at least, my lord.
Therefore, no directions can be issued to them. Petitioners are permitted to make a fresh representation, and after following up with such representation to seek appropriate remedies.
May I pray, my lord? Within 2 weeks, we will made.
First, you do that, sir.
And then let the time may be given.
Not yet. You first do that.
Weekly list item 9.
None appears dismissal, no prosecution.
Weekly list item 10.
Item 10, you will also pray for 1 week time to remove defect.
Defects be removed within a week. List thereafter.
Weekly list item 11.
None appears dismissal, no prosecution.
Weekly list item 12.
Same. None appears dismissal, no.
Weekly list item 13.
May I please alert, sir? Alert, the petitioners enter Gochar land of the petitioners village have been encroached by few anti-socials, my lord. They have my lord, constructed a temple and dwelling houses are residing over there. I made a representation by the Annexure 2, my lord. That has not been acted upon.
Is there any proof of?
I have handed over to them personally, my lord, to the Sahil. I'll make a fresh representation. Let's see.
Counsel, the petitioner seeks leave to make a fresh representation, and after following up on such a representation to seek appropriate remedies in accordance with law. Dispose of is withdrawn with liberty spirit.
Weekly list item 14.
Pardon, my lord. Item 10, my lord. I am appear, my lord, for removal of defect, my lord. Item 10, my lord.
We are not, sir. We are on item 14, sir.
Weekly list item 14.
Item 14 became infructuous because that.
All right. Counsel, the petitioner says.
No, we transfer.
I am for the department.
Weekly list item 15.
Infructuous, disposed of infructuous. Both 14, both matter. 15, none appears, dismissal, non-prosecution.
Weekly list item 16.
My lord, item 16 is a similar case wherein sub-rule 5 of rule 8 of Orissa Panchayat Executive Officer Service Method of Recruitment and Condition of Service Rules 2021 is under challenge. This Honorable Court in a batch of cases has issued notice WPC number 22464 by 2021 directing the opposite parties to file counter within 6 weeks.
When is it coming up, sir?
That is, my lord directed on 24/8/2021 to file counter within 6 weeks. It has not come. WPC number 22464 by 2021.
notice list along with 22464 of 2021 after 12 weeks.
My lord, as an interim measure, it is directed that any action pursuant to amendment rules.
All actions taken pursuant in the meanwhile we subject to the outcome of the petition.
My lord, I'll serve extra copies within 3 days, my lord.
Weekly list item 17.
17 and 18, some similar matter might have fixed to 28th of June. In the meantime, I will remove the defect. Here the challenge has been made to an order which is no more in force. It has already been repealed.
Oh,
To
2004.
Annexure 3, page 43.
It's already repealed, sir.
My lord, I've already fixed to 28th of June. My lord, all the batch cases coming. Where the this repeal has
Doesn't
been.
matter. We'll deal with it when that day will be deal. Now we'll deal with this.
My lord, I will remove the defect. My lord, keep it
No,
next
not
week.
defect. The prayer itself is wrong, sir.
My lord, keep it to
This
next
is
week.
repealed. This order is repealed.
My lord, I will satisfy. My lord, I will keep it next week. My lord.
If it is repealed, how can you challenge it, sir?
Well, I am challenging the clause, my lord, the bylaws of the 2004 granting order, my lord. 2004 granting order, clause 7, my lord, I am challenging.
No, he's challenging the repeal itself.
2004 granting order
This is the
says,
prayer.
clause 7
Challenging
says,
as well as the repealing provision.
my lord, 2004 granting order, I am challenging,
that
clause
itself
7
has already-
says, those persons.
Another order has come in 2009. And this is barred by delay.
Yeah. So you better have proper prayers, sir. Council petitioner seeks leave to withdraw this petition with liberty to file a better petition in accordance with law. Dismissed. This post is withdrawn with liberty to both these petitions.
Weekly list item 19.
My lord, the matter is regarding the construction of septic treatment plant, my lord, on the Gochar land of the petitioners, my lord. Before de-reserving the land and before obtaining consent from the pollution board, my lord. And the lordship on the earlier occasion had directed the opposite party to take a decision on the representation. I have the order of the your lordship. I have quoted in the para 4 of my.
So the SCTP in Jagat Singhpur is under construction. Is going to be complete by end of March. Now we can't influence and interfere with all this, sir.
Your lordship may kindly see the grievance of the petitioner, my lord. Consent is a requirement, my lord. The proposal was made in the year 2021 for the construction. Before giving the proposal, Annexure 7-year lordship, 6-year lordship may kindly see tender process was over. My lord, the process, the construction site was somewhere else,
So
my
now
lord.
construction is over, sir. The treatment plant has come up already.
My lord,
This
My
is the
lord,
second round of litigation pursuant to the earlier order dated.
your lordship may
This court,
direct them to
the
comply all the
representation dated
formalities
16th April
requirement.
2021 of the petitioners has been examined in detail by the collector and district magistrate Jagat Singhpur and has been rejected by the impugn order dated 2nd August 2021. Paragraph. The grievance in the present petition is regarding the location of the septage treatment plant, bracket STP, on Khata number 1204, plot 4247, AC 3.58 decimal. On the ground, it is Gochar land. The perusal of the impugned order reveals it is and it's seen that the land in question has already been de-reserved after complying with the due procedure. The septic treatment plant in question has already been completed. Is proposed to be completed by the end of this month. The decision to have a septic treatment plant is also in conformity with the decision of the National Green Tribunal. Having considered learned counsel submissions of learned counsel petitioner, the court is not persuaded that the impugned order dated 2nd August 2021 of the collector suffers from any legal infirmity. The petition is dismissed.
Weekly list item 20.
Your Lordship may direct to all observe the formalities. They must get the consent from the pollution board, my lord.
All right.
Weekly list item 20.
May I please, Your Lordship? Well, the petitioners in this PIL is seeking for a direction to the opposite party number 4 to implement Annexure 13 at page 96. The order issued by the NCPCR directing to implement the syllabus issued by the NCRT, but that direction has not been complied with by the at page 96, Your Lordship, Annexure 13. That the ICSE schools are the ICSE schools and affiliated schools in India, so they are not implementing the order issued by NCPCR, directing to implement section 29 of the RT Act, that the syllabus and the textbook issued by the NCRTC fixing the guidelines and syllabus textbook to be adopted. But all the
who's for the department?
I am for the
Why don't you take instructions, Mr. Mahapatra?
Yes, my lord, I will take instructions.
Mr. Dayananda Mr. Deepti Ranjan Mahapatra, appearing on behalf of the opposite parties.
For 1 and 2, I am there. 1 and 2.
Yeah. Opposite parties.
OP number 6, my lord.
6. That is a school and mass education department. 6 time for instructions. List on 26th April.
Weekly list item 21.
Defects. Mr. Manthi, there are defects. Is it covered?
Yes, in fact, the copy is short. The other defect is regarding that placing and other.
Is it covered?
Yes, my lord.
My lord, disposed of the other.
My lord, I may pray, just hear me for 10 minutes. It's not covered because the earlier occasion, actually I filed 5 writ petitions for the same issue of the same assessee. 2 was disposed of because alternative remedy, and my lord didn't want to interfere. My lord, actually I would like to say that this is a fit case for indulgence of this court. And facts may be heard for 10 minutes, I will say. Thereafter, my lord can take a decision. This is the case where the maintenance of the writ petition before the High Court. Here, there is alternative remedy was available, and the High Court dismissed the writ petition. The Supreme Court has held, and how, my lord, I would like to draw my lord's attention to page number 17 of this judgment, where the exception they are saying if there is a infringement of fundamental right.
It's always there, sir.
And then natural justice
Correct,
or
correct.
lack of jurisdiction.
Yes, yes.
Or challenge of virus.
Correct.
In my case, that fundamental right or
It's not like a checklist, sir. These are not supposed to be like checklist.
my lord,
Then the other statutory authority no work to do, sir.
my lord, just may hear me for 10 minutes, the factual aspect. Thereafter, my lord can take a decision. I have nothing to say.
All right.
My lord, in this case, the assessee happens to be a firm who executes SWAS contract And the year involved is assessment year 14, 15, 15, 16, 16, 17, 17, 18, 18, 19. 2 has been dismissed and today the 3 is here. I'll be taking up the first case, that is 6657 repeats 6572. In all these cases, I filed my income tax return. And the first year 14, 15, 143, 3 assessment was also made. And he also suffered appeal. And in 27 of February 2019, a raid was conducted, search and seizure was conducted in the business premises of the firm. Thereafter, 143A notice was issued for all the years, and assessment was also made under section 153A. Consequential to this search, 201 order and 201A order was passed. Now, 201 is, I'm a contractor, I am supposed to pay certain things, certain expenses. Suppose I'm paying to the subcontractor or royalty and other things. In certain cases, I have to also deduct TDS. Now, TDS provision from section 192 to 194 LA, I have to comply. Statutorily, I have to deduct certain TDSs and then deposit. Now, 201 says, if there is a liability or a requirement to deduct, the wording is, there is a liability or requirement to deduct, and I don't deduct or short deduct, or after deduction, I don't deposit. Then only 201 can be invoked. In my cases, I have filed 26Q return. If I deduct TDS, I have to also file a return under section 26Q, and it can be assessed under section 201. I have been assessed under section 143 scrutiny assessment for the year 14-15, and there was no contravention of section 40A IA. Now, my lord, two sections I'd like to draw your attention, section 201 and section 40A IA. First, I'll say to section 40A IA, my lord. Section 40A IA speaks.
Mr. Mahapatra, you have the orders.
Section 40.
The order just now supplied.
No, that's
the other 2 matters of this SSC.
Yes, madam.
We've already passed orders in the other 2 matters of this SSC. Where is that?
My lord,
the date of the order, sir.
Date of order. Friday.
Yes, my lord. That is Friday. That is 6660, my lord. WPC 6660 of 2022.
2022.
My lord.
Get that 660 of 2022. Friday means Thursday, 17th.
Thursday, my lord.
17th March. Yes, continue, sir.
Well, section 40 says, notwithstanding anything to the contrary in section 30 to 38, the following amount shall not be deducted in computing the income chargeable under the head profit and gains business of profession. Certain expenses will not be allowed and you will be taxed on that. Now, A says, in case of any assessment. Now, IA, 40A, IA says, 30% of any sum payable to a resident. Previously, it was 100%. On which tax is a deductible at source under chapter XBIIB, and such tax has not been deducted or after deduction has not been paid on or before the due date specified in subsection 1, section 139. Now, in my case, in 14-15, there was one disallowance, that is subcontract payment amounting to 1.70 crore by the assessing authority, which was deleted by the CIT. There was no other, all other payments, there was no TDS made to be done, and there was no infringement of section 40A IA. Now, after such, you are reopening all my assessments, and section 201 says, my lord, can I have a glance to section 201, the wording of section 201.
Sir, at the end of the day, you still have to tell us why all this can't be argued.
My lord, because
in appeal.
Because I don't have to deduct TDS. It has been quantified, and certain cases 143(2) notice has not been issued. It is a sausager case. There was nothing, no incriminating material found. I have annexed the Panchanama in all these years. My lord, kindly have a glance at the Panchanama, because he is referring to the sausager and say he is passing this order consequence to the procedure, my lord can have a glance at the Panchanama I have given. There is no incrementing document. There is no whisper slightly or any document saying that I have not deducted TDS. Now he is presuming and assuming there is a short deduction, which cannot be done. So he has no jurisdiction to invoke section 201. And I have taken 5 grounds. In fact, during the COVID period, when there was complete lockdown or shutdown at Sambalpur, I have challenged the territorial jurisdiction. I have also challenged the jurisdiction that he doesn't have the jurisdiction to invoke section 201. And there is neither a single whisper anywhere in the search, in the seized document or material that I have not deducted TDS or there is contravention of section 40IA in any of the years. So how he has the jurisdiction to invoke section 201, which specifically says if there is a requirement or that means there is a default. You have to find out, in fact, I have not deducted or not deposited or there is a short deduction. In my case, there is nothing and there is no incremental material and all these years are abated. So without any incremental document also he cannot. And there is a decision of this court, Jami, and there my lord held in the sausager cases abated assessments without any incremental document. The jurisdiction to invoke section 143 is not there. And 201, Supreme Court held, is an assessment. In fact, 201, there is no procedure for assessment. It follows the procedure of any, like if you are going for 147, then it follows the procedure of 147. If you are going for 153, then it follows the procedure of 153. So 201 has been held by the Supreme Court as well as the High Court of Bombay. That is a kind of assessment. And they have also said, if there is a reopening under section 147, then the similar procedure, 4 years, 6 years, you have to order for 201. And if it is 153, then you have to add up 153. I'm amenable to 153. In these cases, all these years, 14, 15, 15, 16, 16, 17, 17, 18, 19, 5 years. These are all 5 years already abated. Assessment order has been passed or 143, 2 notice has not been issued. So it is complete. Assessment is over. So you cannot invoke without any incremental document or anywhere, any indication that I have not deducted TDS. My lord can only see 1 year, 14, 15, that is WPC number 66572022, where I have annexed the assessment order, the appellate order, and the Panchanama also, and again 153A order. My lord can have a glance of all these orders, and then I'll go to the 201 order also. My lord can look into that, and then my lord, if you decide not to interfere, because and another manner, the order, just have a look at the 201 order itself. I'll just read 3-4 paragraphs, then my lord.
No. 10 minutes are over, sir. You say counsel to the petitioner frankly states that in relation to the same petitioner for 2 other assessment years.
For 3 others.
For 3 other, no. 2 others we've already relegated you to the statutory authority.
Well,
for 2 other AYs, the petitioner has already been relegated by this court by an order dated 17 March 2022 in writ petition civil 66
660 of 2020. 6659
6659 and 6660 of 2022 to the statutory remedy of appeal. Consequently, the court is not inclined to entertain these writ petitions as well, relegating the petitioner to the statutory remedy of appeal against the impugned orders. The petitions are disposed of.
Blessed. Weekly list item 22.
None appears the system numbers.
I am for the union of India, my lord.
All right.
Weekly list item 23.
But in this case, I am appearing for the opposite party 9 to 13.
None appears the system numbers.
Weekly list item 24.
My presence may be recorded.
Yes.
Obliged.
None appears the system numbers.
Weekly list item 26.
None appears the system.
26, my
Weekly list item 27.
26, my lord.
Yes, please. EIL
My lord,
Lakhmara Gram Panchayat.
my lord.
What
Here,
is the
although there is no stay order, my lord, the impugn notification.
So
My
actually last time, sir, there is a problem here.
Yes, madam.
My
See, you had in your reply
My lord.
said it's going to take some time because they are in Paikmal
Yes,
and it is closer to them.
yes, madam.
And they are going to be asked to go to that other place,
Paikmal.
Padampur, which is 40 kilometers away.
No, my lord.
No, my lord.
Padampur is only 15 kilometers away. Paikmal is 40 kilometers
Aha.
away.
Dr.
Padampur
See,
is the convenient place for
Correct.
the-
Padampur is more convenient for
Yes,
them.
my
Page two of our counter affidavit, we have stated that, my lord.
So you have agreed with them.
Yes, my
My lord, as
Your
per the-
report also agrees with them.
Yes. the report
Then why
says
are
so.
you not doing something about it?
Yes, sir.
You file a reply saying what have you done about it? All right.
This was filed in 2013, my lord.
That's right. You
And
tell
I
us
believe-
now what has happened.
Yes, madam.
In the reply filed way back on 5th August 2013, the state authorities had agreed with the petitioners that by combining the Padampur and Paikmal blocks, great inconvenience would be caused to the present petitioners, as Paikmal is 40 kilometers away for them to access. Full stop. The counter affidavit further stated that the reorganization of the blocks will take some time at the government level. Full stop. The government will now file a further affidavit at least 1 week prior to the next date, explaining what steps have been taken for reorganization. List on 29th June.
Weekly list item 27.
So item 27, brief has been transferred, Lordship.
All right. The petitioner says that there are no instructions. Yes.
Weekly list item 28.
None appears dismissed for non-prosecution.
Weekly list item 29.
29 infructuous, Your Lordship.
Infructuous.
I am for opposite but not one.
All right.
Weekly list item 31.
30.
I am for the opposite part.
Opposite party. It's dismissed for non-prosecution. All right. It's already been withdrawn, sir. It's already withdrawn. Okay.
Weekly list item 31.
None appears dismissed for non-prosecution.
Weekly list item 32.
The contempt petition is closed. There are 3 matters.
Weekly list item 32.
None appears dismissed for non-prosecution.
Weekly list item 33.
Opposite party CTA matters.
All right. None appears dismissed for non-prosecution.
Weekly list item 34.
34 Miller. I am filing my photographs and video clips.
My goodness. This is cut Jodi, is it? This is cut Jodi.
Miller.
Wow. Just play the video. Please play the video. When did you take the photographs?
Photographs Miller on 23 to 2020.
23?
Two Miller. This month. Last month.
Last one. All right. Why have you implemented JICA?
JICA, my lord, the work has been taken by JICA, my lord.
Oh.
The drainage work, my lord.
Yeah, play it. Why did you stop it? अरे why is he stopping? आप क्यों रोकते हैं इसको?
Play करो.
But we can already see it here. इसमें दिख रहा है. Are you able to see a video there?
Another.
No.
No, madam, no.
अच्छा उसको share कर.
My lord, another pen drive is there.
All right. Wait. Now?
It has not started. Yes, ma'am.
This is the river itself. Oh. Have you tested the water? Have you tested the water? Have you tested the water?
No.
All right. You say the petitioner has placed. Mr. Nayak, are you there?
I'm here, my lord.
You saw the video. You saw the video, Mr. Nayak? Where is he?
My lord, just in the video.
Mr. Nayak, do you have your own laboratory people who can test the water contamination? The corporation is supposed to have, no?
I'll take instructions. I think.
No. Suppose I ask you to test the level of pollution in the drinking water that you're supplying to the Cuttack city, will you not be able to do that?
I think, my lord, that is under the jurisdiction of the public health.
No, I'm sure the CMC has some laboratory where you do all this. Don't you test the water level, please?
I'm not aware.
Quality of the water.
I'm not aware, my lord. I'll take instructions and come back to my lord.
No, you better now, without wasting time, actually go to this very spot, pick up samples, test it. You say the petitioner is placed before the court a video clip as well as photographs taken on 23rd February 2022 of discharge of untreated effluents into the Katjodi River. The video has been viewed in the court in the presence of counsel for the Cuttack Municipal Corporation, Mr. Debashish Nayak. A direction is issued both to the CMC as well as the State Pollution Control Board to immediately depute a team to collect samples of the water at the place of discharge, test the water quality, and file the test report before this court within 3 days. Stop.
May my lord, there's one issue that the municipal elections are on the 24th. My lord,
Sir,
kindly give me
no effluent stops for municipal election. This is the unfortunate part. Do we stop discharging effluents because of municipal election? We don't. We don't. That's why. Within the next 3 days. So list on Friday. The concerned, which will be the engineer, what irrigation, what is this? What department?
Watco, I think, my lord, is the authority that looks after all these things.
You say notice also be issued to the chairman and managing director Watco to take immediate corrective action and to remain present in virtual mode in the next date. The Secretary of the State Pollution Control Board will also remain present in virtual mode on the next date.
I am appealing for the Pollution Control Board. We have already filed a counter.
Counter and all will not do. You better send a team right now to that spot which you saw.
Yes. I will file the
test results, and your secretary should be present. Member secretary, right?
Yes.
Member secretary will remain present in virtual mode. Sir, something has to be done. This is not on. Not in 2022. If you are going to have this kind of a thing, what is the point?
There is no sewage system. But
You have to do something, sir. You are the Pollution Control Board.
Board has been.
You have to crack the whip.
You also kindly see my counter. We have already writing time and again to the municipal.
Sir, writing will not do time to crack the whip. All right, you have enough powers under the Water Act. You have to do it. Whether it's CMC or anyone. List on. List on 25th March. This Friday, sir.
Yes.
Ask them to remain present.
Here in person?
No, we have said in virtual mode, you ask them to remain present virtual mode. Mr. Nayak, your person will also be remaining present, all right? Whomever you are deputing. The representative of the CMC interested with the task will also remain present in virtual mode on the next date. List on 25th March at 10:30 a.m. sir. Yes.
Weekly list item
10:30 on 25th.
Weekly list item 35.
You leave the video clip here, sir. The video clip be kept on record. Right. The pen drive containing the video clip shall remain on record. You have to give copies of the video clips to Mr. Nayak and this counsel for the Pollution Control Board. Please collect the video clips from him.
By tomorrow, my lord.
And you explain to them where this location is. They should know where to go and collect the water sample. Yes.
Weekly list item 35.
None appears dismissed from non-prosecution.
Weekly list item 36.
May I please? Our petitioner was appointed as a junior clerk, my lord. While she was continuing, Annexure 1, page 23 was communicated to the petitioner, my lord.
District Judge Bolangir.
My lord. Annexure 1, page 23.
So we'll take it at the end of the board, sir.
My lord.
Actually, we can't take it up today. List on 5th April. No, sorry, not 5th April. 5th July.
5th July, man.
Yes, sir.
Weekly list item 37.
None appears dismissed from non-prosecution.
Weekly list item 38.
Item 38 on the last occasion, Lordship directed the OP4 to make an inquiry and submit a report, my lord. Today in the morning, I have spoken to him and he requires some little more time, my lord.
All right. counsel for the petitioner, opposite party states that opposite party number 4 seeks some more time for filing a report. The report will positively be submitted by 9th May 2022. List on 13th May. Sir.
Weekly list item 39.
Item 39, I am for the petitioner. I need some time to file rejoinder affidavit.
All right, rejoinder be filed for the next date. 11 July.
Weekly list item 40.
Item 40, my lord, I am for the petitioner, my lord. Your lordship are directed for issuance of notice, and the opposite parties were directed to file the counter affidavit by the next date, my lord, by today. But no counter affidavit has been served on me.
My lord, I am for the OP number 4.
OP number 4
Which time for filing counter?
All opposite parties are granted the last opportunity to file reply within 4 weeks. Rejoinder for next. 30th June, 30 June. Done. All right.
Now, 30